Someone was told I have a case of James Williams on today's topic. Is that him? And which
It's a
is it?
recall.
Huh? Oh, Danny Williams, is that,
Yeah, he said you were, it's a request for appeal.
is what?
A request for a PR bond.
Oh, I see, okay. Um, Is that a domestic violence case?
Or do you-
Do we say something with all the information?
you need to go back.
Okay, let me see then. Yeah, I can. Okay. We can do it and get it off of today's topic.
Yeah,
Do I need
well,
to, do I need
take
to
it
know?
on.
Okay.
All right, everyone, I'm going to call the docket. If you're here, let me know you are here. If you don't answer the docket, I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Jonathan Ben. If there's a Jeanette Simmons here, your case has been reset for January 9th. Hector Laura Sanchez is in custody. If there is an Arthur Scarborough, your case has been reset for January 9th. In custody, we have Jeremiah Johnson, Mark Reyes, Harold Esther. Mark Ivy. Mark Ivy. In custody, we have Placido Jaquez. Jose De La Bosque. Thank you. If there is a Andrew Velasquez, your case has been closed. Damon Hill. Damon Hill. In custody, we have Nathan Martinez. John Garza. Alicia Small. Alicia Small. Crystal Castro.
Because I'm here for her, I have not seen it.
Okay. Leroy Settles. Joseph Garza.
Here, ma'am.
Juan Tehran.
Here, ma'am.
Guillermo Rodriguez. Guillermo
I
Rodriguez.
think that's the judge.
Oh, thank you. Armando Rodriguez. Armando Rodriguez. In custody, we have Melanie Flores, Cesar Vasquez, Cesar Vasquez. Bree Madrigal. Bree Madrigal. Am I pronouncing that last name correctly? Is that from Encanto?
Yes.
Well, you can tell I just know about Bruno. Isabel Garza. Isabel Garza. Raymond Cavazos. Okay, thank you. John Michael Garza. Thank you. Melissa Carlson. In custody, we have Nathan Martinez, Starlin Rodriguez. Gabriel Hinojosa.
Present, Your Honor.
Leo Gonzalez. Leo Gonzalez. Philip Singleton.
Here.
Vaughn Skirvin. Robert Lee Luna. In custody, we have Kevin Luna. Jasmine Hardaway. Jasmine Hardaway. In custody, we have Carlos Romero. Jacob Glandon. Jacob Glandon. In custody, we have Joseph Ramirez, Donald Davis, Thomas Ollie, Angelica Gonzalez. In custody, we have Arturo Rivera and John Zulaka. April Polinar,
Present, Your Honor.
Lance Paxson,
Judge, I'm present.
okay. Stevie Stokes and Angel Peralta, Danny Williams are in custody. Gregory Gonzalez will be by Zoom. David Sanchez, Curtis Williams. All right, is there anyone who walked in late or your name was not called? All right, everyone, these are the rules of the court. Attorneys, I try to keep the middle of the courtroom as least congested as possible. As everyone is aware, should be aware, there appears to be an uptick in flu, pneumonia, COVID, a combination of everything. And I know a lot of people are going to be doing a lot of traveling. So let's try to keep everybody healthy. And the way we do that is we try to keep the center of the room as least congested as possible. If you have a file, there are files to my right and to my left. Just take your file, whatever it is. And if you want to confer with the state, just sit it down on their desk. They will call you when they're ready to speak to you. Do not approach the court if you have not spoken to your client and have not conferred with the state. Once you're ready to approach, just grab your file. The clerk will place it here. Just have a seat and I will call you in the order in which you'll appear. First will be first and last will be last. If you have a client who is in custody, just ask the deputy to have them brought out. Once you requested your client, do not leave the courtroom because that messes with logistics. If you have a client who needs an interpreter, do not come and approach the court and say, well, I speak their language, because it needs to be done through a translator. So once the translator is called, please do not leave the courtroom. So today is Thursday. We're closer to Friday than we've ever been this week. So just think about the greatness that Friday brings. Be kind to each other and have patience. Everyone, please confer.
Still Castro. Oh, nobody. Yes.
Are you the one blowing up my phone?
It says David Gomez, Antino, and Christopher Garza. I just want you to know that I'm in the middle of a jury trial. And that judge is jealous of her time. I gotta run back.
Hey, which trial are you in?
Angelica Jimenez over on the civil side.
Oh, well,
It's a silly CPS case, but I've been there since Monday. And I'm not leaving you hanging, and I'm gonna report you and hear all these stuff the moment I'm able to.
all right, thank you.
Thank you, Your Honor. I'm sorry. It's a PSI. All right. Yes. It's been introduced.
Neil Gonzalez.
Thank you. I'm gonna walk over there and come right back.
Arnold David. Caesar
Well,
Vasquez.
for today, for the 2 days,
Thomas
we
Ollie.
needed a rough chance.
Lance Paxton.
One person needed.
Harold Floyd Esther. Jasmine Leroy. Armando Rodriguez.
Look at it. Yeah, in this section.
Need one right here. No.
Let's go on.
You're hurting me, man. Okay, I'm not very peaceful days. I thought I had peaceful days. It's today. Oh, it's tomorrow. Okay.
But you're here early.
I know, Judge. Well, I was so excited.
day early.
I got all my motions done, everything ready for everybody. So I was like, this won't take but a few minutes. We're gonna get in, take care of business and get it done.
Hey, but you did take care of it. You came and you realized it's not set today. It's like you did it quick.
Oh, that's fine. So tomorrow night. Okay, cool. See you in the morning. Get back tomorrow, Judge. Take care.
Who's there on Crystal Castro?
Yes, Your Honor.
Yes.
Good morning, Your Honor. How are you?
Good morning.
I have no contact with Ms. Castro.
Have you tried calling her bondsman?
Judge, I did not try to call her.
All right, is she on a PR bond or? It's a 2022 CR 10417.
No, she's on a surety bond. It's the action. Have the phone number. Are you ready?
Yes.
210
Uh-huh.
5487.
I will call him right now, Judge, and I will report back to you.
All right, thank you. All right, they're not ready on the.
That's your indictment. Just hold on. Okay. Okay. I don't know. Give me. Okay, yeah, just give me a little bit.
Sure. It's just to explain. It was local origin.
Oh, he's okay. So this is a transfer of the child. What is Danny? Or Oh, you're doing one. Oh. I'll do that. Oh, sorry. What you need?
Hector Laura Sanchez.
Okay, all right, thank you. All right, can I see that so I can write on that line? All right, just one. And can I see the following Crystal Castro again?
How you doing?
How are you?
That's for him too, I guess he was on before, that's why he was in jail.
Okay.
He approached on Matty call,
Oh, no, we don't.
because she wasn't here and I have a letter to show the judge.
Okay.
All right, what's the update on Crystal?
Said I called the bondsman said she gave me the number. I called the number, but there's no voicemail.
Okay, all right, we're gonna go on the record. Brent, are you ready?
Yes.
Court is calling 2020 CR 10417, State of Texas versus Crystal Ann Castro. Could I have parties announced for the record for the state?
Danny Escobar from the state of Texas.
Defense?
Isidro Montoya, Your Honor.
All right, this hearing was scheduled at 9 a.m. It's now 9:16 a.m. The defendant is not present. Deputy, was the defendant present outside the courtroom?
No, Your Honor, it was somebody in the hallway.
All right, defense, have you had any contact with your client?
No, Judge, number I had originally disconnected. I called the bondsman, gave me a new number. The voice box is full. The bondsman tells me she's been reporting to the bonding company and she knew about the court date. And so but I have not had any contact with her.
All right. State,
Your Honor, statement was for a bond forfeiture for a warrant to be issued.
that'll be granted. If your client presents herself, then the court will reconsider.
Thank you, Judge.
All right, you're welcome. Thank you.
May I be excused, Judge?
Yes.
Thank you. Excuse me,
Yes.
I was just pondering.
Well, I'll reconsider. She's
Thank you.
present.
Thank you.
You're welcome. Sometimes it takes saying somebody's name 3 times. All right. Who's here? I'm Bree Madriel. Yes, where's your client?
Judge, I worked on this all day yesterday. She's getting chemotherapy right now in University Hospital. But it took them a while to send a letter and I just got the email right here.
Okay,
I'm happy.
I know you're an officer of the court, but I.
No, I want you to look at it. I thought maybe you'd be reluctant to look at it because of COVID or whatever. And just to let you know, I normally don't let other people hold my phone.
Oh, okay, I appreciate it.
I'm just kidding. But I normally don't, you never know. People always want to use my phone. It's like, I'll dial the number for you.
All right, let's go off the record for a moment. Can we do this? Can I see some room from the state? Let me forward this to them.
And are you gonna call what?
No, I don't have the file.
Oh, they're upstairs.
No, the files, they're in the box.
Okay.
It's Crystal Castro. Yes, Castro.
No.
Okay.
Is it Crystal?
No, it's fine. Okay.
No, I'm sorry. It's Madrigal. Okay, I'm sorry. You know what? Once I watch,
I think we need to put you in contact and
Like
repeat
in
everything.
Castro.
yes, I know. I'm working on it.
I think that's the court.
Oh.
I know, I love them.
So how you been doing?
Except for my leg. Other than that.
Okay, do you know there's some place that you can go where they have, you actually go to the house and they have different doors you enter. And the last door you enter, you're with your entire family, you take a photo. It is so nice. It's in New York, I think they said.
I love it. Be happy.
Oscar, I just emailed it to you all, to both, to your both. So you should be able to look at it. Okay, Madrigal. See, I can never roll my R's. That's the problem.
Madrigal. I can't even say it. Madrigal. That is hard to say if you don't roll.
See, that's Brenna. Now that they realize I can't roll my R's, now people are more sympathetic. Thank you. That's what's throwing me off. I can't roll the R's. Who's here on Lance Paxson? All right, and is Mr. Paxson?
I didn't bring him. I had mentioned to Norma that I was going to bring him through satellite after we got a bond set. I didn't know I needed to bring him here.
Okay. They're not going to put this in the bond system until he's actually in custody. So you need to let them know that he's in custody downstairs at the satellite office before the clerks will put it in the system.
Okay,
Isn't that correct?
because I don't know if satellite will take him if he's not in the system.
Oh, no, yeah, they will. They have to call us before to make sure that there is content, but
Okay.
as soon as he's over, he's in the office, they give us a call.
Okay,
So whenever he gets down there.
okay, very good. So some of the things on his motion to adjudicate, like his criminal, his community service, he has already set up to do during the San Antonio Stock Show and Rodeo, his last 21 hours.
All right, can you mute us, please? All right, who's on Kevin Luna?
Oh, yeah.
All right, and is Luna in custody?
Yeah, he's in custody. He's been brought out, so I can just talk to him.
Okay, sure. So the last time we were here was for this, Mr. Luna is right next to you. Brenda, and I said his name only twice and he appeared. Okay. So the last time we were here, it has to do with videos.
Yes, Judge, so I just uploaded those to e-discovery. It took a lot of time to figure out how to get them to work, but we were able to convert them to a video file and actually works.
Yeah, that was the problem we've been having all along.
Okay, so is the only discovery issue the videos?
As far as to my knowledge.
I'm not aware of anything else.
Yeah. We will make an appointment at some point to go to the DA, maybe look at their file at the office.
All right, so I'm gonna reset this. As you know, we don't have a first chair. Although my belief is, and what I would always say when I was in the prosecutor's office, that there's no difference between the first chair, third chair, second chair. Everybody has their law degree and their license. And all files, you still have discovery, the same thing. But I understand that you don't want to make any decisions.
Well,
With
it's
this.
it's more one of those things that I don't want to make the wrong decision and
Yeah.
then someone comes in later and has to clean up.
You wouldn't make a wrong decision. All right, so what we're gonna do, usually I don't give these type of long dates, but I'm gonna have you brought back in February.
Okay.
If you want him brought back sooner, just let us know. And if you want to check in and see if a first chair has been assigned to this court, which I'm assured they will be at the beginning of the new year. So we can do it that way. Ms. Ferguson, on Kevin Luna, we're just gonna set it for discovery to make sure you all have all your discovery. If we can set it in February, please. Mid-February.
We can do the start week.
All right, the day before Valentine's Day. Do you have anything special planned?
On the 13th, no.
All right, I mean, just in case something pops up. All right, so we'll be back on the 13th at 9 a.m. and I just put it as a discovery.
Yes, ma'am.
And then I'm not sure how this is indicted, but if you all can, I don't know if you're planning on doing death penalty or whatever you're planning on doing. If you all could have some idea, I'm not going to make you make the announcement on February 13th, but if you could start looking towards that, so I'll know how we're proceeding. All right, and you can confer with your client.
All right, thank you.
Thank you. Yes. Thank you.
Oh, they're there for you. Okay. So you get your copy, sir.
Thank you very much.
Oh, yeah, of course.
It's not my fault, but.
Here we go. These are your copies.
Thank you.
Thanks. Here we go.
Well, I look at it. It's got my name on it. Don't know what it is.
In the back, absolutely.
Thanks. I have no idea what this is. Sorry, I look at it, thanks.
Here it is. Is this on the docket today?
Sorry, I jumped again. Go ahead.
This is Paxson.
Yeah, that's the one that is, has to do with Oscar Outlet.
You're welcome. Bye. All right, on this one, the motion has been withdrawn. All right, who's here on Gabriel Inosa?
I'm just.
Brenda, we keep seeing Kelly Kittle. It's like he enjoyed trial with us.
I'll be here tomorrow too. I like y'all so much that I
Right. And you have a haircut.
got a haircut. I
Yeah.
should have done that before that trial, but
Brenda, I try to notice everything. I'm trying to work on my identification skills. So, but I like the tie too.
thank you. It's Christmas.
All right, so what are we doing with Mr. Inosa?
Judge, we're here for plea deadline date. We discussed the plea offer with Mr. Hinojosa and he's rejected it and we're pressing trial.
Okay, let me find him on the docket.
Is that Stephen Stokes?
No, this is, no, it's.
Can I- Which page?
Page 10.
All right, thank you. All right. And I had admonished you about being late last time, and you're on time today. Thank you. All right, Ms. Ferguson, can I have a jury trial date? How long do you expect this trial to last?
Couple days,
All right,
probably day and a half.
any videos?
Yes.
Long? Okay. Well, I should stop saying long. How long are the videos?
Well, those videos are always 7 hours, Judge.
Okay. All right, Ms. Ferguson, they're telling me it's gonna be 2 days for jury trial. Is that with jury selection or without?
Day and a half without, Judge. So
Okay.
jury selection and then day and a half.
And if he were found guilty, is he going to the court for punishment or jury?
Jury, because it's ag assault. So
Well, no, I know, but
Yeah.
sometimes people are like, I'll go to you, judge.
jury, Judge.
You're right.
And if you could get a acknowledgement of discovery for me today?
Sure. I have them. Give me one of those.
Is there an agreement? Yeah. Judge, I can do March 14th.
That's fine. Judge.
Okay. All right, your jury trial date is going to be March 14th. Your plea deadline date has expired. The court will not consider any plea bargaining agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right, so that'll be at 9 a.m. Ms. Ferguson will give you a reset form. State Criminal Trial Division.
It's family violence.
Oh, it's family violence. Sorry, family violence on Gabriel Inaosa. If you could do an acknowledgement of discovery, please. All right, thank you.
Thank you, Judge. Thank you.
I know, boss, getting up there. Thank you.
Who's here on Angel Peralta? The defense attorney for Angel Peralta? Yes. Are you all ready to proceed?
Yes, Your Honor.
All right, have you completed a trial court certification for right to appear? Okay, Mr. Escobar, could you grab him a trial court certification, please? Thank you. Do you have a flash?
Be right back.
Thank you. Oh, you know what? This is a contested hearing.
Well, I think.
Ah, okay. All right, thank you. And Deputy Laura, can you see if this person is in custody? All right, the court is going to call 2016 CR 8066, State of Texas versus Angel S. Peralta. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense? Are you Mr. Peralta?
Yes, Your Honor.
All right, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Angel S. Peralta who was placed on community supervision in 2016 CR 8066 for the offense of driving while intoxicated third or more on January 9, 2017 for 5 years and extended for a total of 1 year? Is that you?
Yes, Your Honor.
All right. The court is seeing on the docket sheet that the defendant had previously entered pleas of not true to each allegation, and that this was set for a contested hearing today. Mr. Peralta, are you requesting to change your pleas to those allegations?
Yes, Your Honor.
All right, state.
Would you like me to read off?
Yes.
Okay. Violated condition number 2, on or about the 10th day of January 2022 in Bexar County, Texas, the defendant, Angel S. Peralta, is then and there failed to submit to drug testing as directed by the court supervision officer in violation of condition.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 3rd day of January 2022 in Bexar County, Texas, the defendant, Angel S. Peralta, is then and there failed to submit to drug testing as directed by the court or supervision officer in violation of condition.
How do you plead to that? True or not true?
State waives all the violations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Peralta, did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, and sentence you to 10 years in prison and up to $1,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 2 and 2?
Yes.
Court will find violations 2 and 2 true. Is there an agreement?
Yes, Your Honor, there is. It's to extend the defendant's probation for 2 years, a ban for mental health screening, for him to register for the access program through the Center for Healthcare Services, and also to impose DDRF.
All right, is that the agreement?
It is, Your Honor.
Mr. Peralta, are you asking me to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, I have a few questions. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. So why were you not testing? What was stopping you from doing that?
Because I got sick, I got the COVID, I had leg sores, and I couldn't work. They repossessed my truck.
So probation, how was he doing on probation before? Because it seems to me that maybe you were not doing well on probation before because you've been extended before.
I was having family problems. So, but I know.
Judge, it looks like there was issues with drug tests.
Drug tests?
Drug tests due to funds. And it looks like fees were an issue in general due to personal finances. Even a vehicle was repossessed back in October 2022. There was trouble with reporting logging onto Zoom due to his medical conditions, which required isolation. So it looks like fees and medical issues were an issue with reporting compliance probation
Okay.
that we're contributing to. It's not the best.
All right, so we already know DDRF has a long wait. So I mean, is there mental health issues? Do you have any diagnosis?
Well, I take medication because I'm diabetic, I have blood pressure, and sometimes I take my anxiety. I get anxiety, like I get depressed because I'm
Do
not.
you have a
married.
doctor?
Yes, ma'am. Well, I go to Central Med because I don't have insurance. So I have to go there and they're the ones that help me. Because I live by myself, you know, I maintain, I gotta pay rent, pay bills.
All right, is he on ignition interlock or some type of device?
Judge, he's on any devices at this point then, maybe. Oh, I spoke too soon, sorry. He is on lockout as of September 25th, 2022 with Lifesaver.
Will SATF accept him?
I believe they will, Judge, because he previously completed that back in 2017.
All right, this is what I'm gonna do. I'm gonna deny the motion. I'm gonna extend you for 2 years. I'm gonna send you to SATF. And once you release from SATF, I'm gonna do a referral for felony drug court. And felony drug court will be able to help you with your financials as far as getting those in order for you. Or if you don't want to be on probation anymore, I can revoke you and I will send you to prison for 2 years.
No sign for the probation.
Okay. All right, so we're going to extend him 2 years and we'll do the mental health screening while he's in custody. And we will do SATF followed by felony drug court. What is the wait time for SATF?
Just currently the screening for both males and females, about 1 to 2 weeks after medical.
All right. What medical issues do you have?
Medical, like I said, I'm diabetic, I have blood pressure, I get anxiety.
Will SATF accept him if he's diabetic?
Judge, if he receives injection status, he not be. So state.
All right, do you handle your diabetes through injection?
Yeah, I have to inject my insulin.
All right, so what about ISF?
I could check that.
All right, we're gonna see if ISF. Because DDRF, the wait time is 32 weeks, so that's not gonna happen. Let me see something. How old are you?
60.
Okay,
Can I say something, John?
yes,
It kind of makes it difficult for me because I'm illiterate.
okay. All right, just give me, okay, just give me a moment, okay.
You asked me something.
No, just give me one moment. All right, everyone, just stay right here. Everyone, give me one moment. Can I mute it? All right, we're back on the record. All right, so this is what I'm going to do. I'm going to extend you. Could everyone please settle down? I'm going to extend you 2 years. We'll do the mental health screening while in custody. And we're going to do a referral to felony drug court, and he's to remain in custody until accepted. Is there anything else from either side?
No, Your Honor.
All right. So felony drug court will come in and speak to you, and you need to let them know what all your issues are. And don't pretend that you don't have an alcohol problem because you're here for a DWI third. You understand?
Yes, sure.
All right. Thank you.
Thank you.
Who are you guys here for? Yes.
A quick question.
Yes. Can you mute us? We're doing a lot of muting today. Who's here on Jose Del Bosque? Hello.
Morning, Judge.
Good morning. So we're here to see about the lab reports.
Yes, ma'am.
I like your tie.
Christmas time.
Yeah. But I always thought it was nice of Rudolph, after the way they treated him, to be the bigger deer and say, you know what, I'll lead the sleigh. I'm okay. Yes. So do you have the lab reports?
No.
No, Judge, but we spoke with the lab yesterday and the DNA is gonna be pulled in the next batch. And they said that is, once that happens, it's 6 to 8 weeks.
Plus,
Okay.
we're waiting for the lab from DPS, I guess, on
For
the
the
THC.
All right, Ms. Fergus, can you give them a February date, please? The 20? All right, so we'll be back on the 23rd at 9 a.m. And hopefully we have the labs in by then. And if for some reason the labs are not in by then, we're going to have a quick turnaround and witnesses will need to be subpoenaed.
All right, Judge.
All right.
We have one more thing. I filed a motion to modify bond. He wants to go back to Mexico. I think his dad is still in the hospital. Is that?
Well, he's got released from the house, but he's from bed.
Right,
Well,
but the
did you
state
confirm
has,
the state?
the state has agreed to it, so he can go see his dad.
Okay. Well, you all need to write something on this order.
Oh.
Thank you.
Okay.
All right, have a seat. Crystal Castro. Sorry, can you- no, I turned it It should be in there. Is it not in the file? Okay, all right, thanks. I was like, no, I can't believe I lost it. All right, so what is happening with this case?
So I spoke with Ms. Castro, we confirmed, she's in the process of hiring Charles and Brent, BUNK, in this case, and so she hasn't hired them yet, but she's in the process.
When are you hiring him?
I called him earlier, but he was not available.
Now, my question is, when are you gonna hire him?
Oh, today.
All right, so Ms. Ferguson, we're gonna recall this for next week.
Thank-
Ms. Ferguson, what date?
For 19.
Thank you, Honor.
All right, you're gonna have to get a reset form and don't be late for court again, you understand? All right, Ms. Ferguson will give you the reset form for her to sign. Crystal Castro.
Page 7. Page 7.
Pepper, you can have a seat. Oh, thank you.
Juan Tehran. All right, what is happening with this case?
Judge, this is our first setting. We just arrested him at large, posted that fugitive on Halloween. So I haven't even begun the process of reviewing it. I need to look at the forensic interview, things like that. So we're at the.
All right, Ms. Ferguson, can I have a 30-day reset on Juan Tehran?
You can come back on the 24th.
January 24th?
Yes.
All right, we'll come back on January 24th. Yes.
You want to put, come back.
Okay.
What is the name?
Leroy Settles.
Can you put settle?
Raymond Cavazos. All right, and Mr. Cavazos, come forward. All right. What is happening with these cases, counsel?
Judge, we conferred with Mr. Salinas and he's made an offer. And Mr. Cavazos would like an opportunity just a few days to be able to think about it. We can get a reset for maybe sometime in January. And we should be able to resolve the cases. He also has a co-defendant whose attorney is not here, so I need to confer with him also, Mr. Martinez, Jeffrey Martinez. Very fair.
All right, so,
Very unreachable. That's how I say.
so how old are you?
50.
So how much time do you need? Can I bring you back next week? All right, Ms. Ferguson, can we have him back next week for disposition?
Well, not this, but we may decide he may want the trial. I'm not sure, Judge.
Okay, well, we'll bring him back. So you need to let the court know whether or not you're accepting the offer.
On the 19th.
All right, so we're going to come back on the 19th.
Who's the other one?
Jeffrey Martinez.
And Melanie Flores. Co-defendant Melanie Flores.
All right, we'll bring you back on the 19th, okay?
Okay, thank you.
Do you need to speak with your attorney anymore before they take you back?
Yeah. I'll just zoom.
Thank you.
Is it Bradshaw? Is it Bradshaw? Okay.
I think that's.
If there are other attorneys, they're co-defendants, correct?
Yes, Jeffrey Martinez is correct. Melanie Flores. So I'm not sure what.
So are you the sole attorney on all of these cases?
Mhm.
Oh, yes.
State overcharged as well. We need a setting or just.
I'll put it in the system right now, so we're gonna email.
You know, I'm old, so I make.
You wanna read it?
Oh, I'm just telling you, I don't.
Um, can you tell me how much that is doing?
That was a one.
Did they take that one guy back to?
Sorry.
Did they take Mr. White's guy back?
Yes.
Okay, it got reset.
No, he is going to be in felony drug court.
Okay.
Stevie Stokes.
Stokes.
All right, so on this one, we were supposed to be coming back on. Are we back for some reason?
I filed a writ for a bond reduction, Judge,
Ah, okay. Let me,
and then a HIPAA release one.
all right, so we have a motion. He said he filed a bond reduction on Stokes. Okay.
Thank you, Rick.
Because I was like, we're supposed to be here back on February 9th.
We were here last week, Judge, and I advised the court I was gonna file a bond reduction.
Okay.
Few days.
Oh. All right, just have him take a seat and
Okay.
then we'll come back to
Can't
that.
find it. I have a copy I can file right now.
All right, if you just file the copy.
Yeah,
then,
sure.
that'd be good.
Thank you.
And if you have a seat. All right, Leroy Settles.
Not here.
Oh, yeah, where's your client?
He's not present for honor. So I asked that I be excused and maybe you give him until noon. I'll come, I've tried to contact him, but
Is he on a PR bond or commercial bond?
I'm not quite sure, to be honest.
If you want to check in the back and maybe you can call the bondsman about, I'll give him till 10:30.
Okay, thank you.
You're welcome.
Hello, Your Honor, may I approach?
Yes.
Off docket matter, persons in custody, Judge. The state did tender this motion. I would like to give it to you on their behalf.
All right, if you can have them pull the file from the back.
Here is, Judge.
Ah,
Yeah, they had a.
you are so prepared.
Oh, yes, try to make things efficient as possible, Judge.
Here,
I truly appreciate it, Your Honor.
you're welcome.
Go ahead and take it to the back. This was- it's on Mr.
Is that today?
Yeah, oh no, it was not set today. Even in May, we did a misdemeanor plea at Docket. Now they're going to discuss this.
Okay, that's. Okay.
Norma, did you send me that, thing from the bar that they wanted me to fill out? The questionnaire?
I couldn't find it.
Okay.
I think I did. No. Let me check if I put it in another file.
Okay.
Maybe I'll keep everything in one. It's still in there.
Oh, okay. All right, thank you.
Okay.
I think this is. Okay.
All right. Mr. Kittle? With regards to your motion for a HIPAA order,
Yes.
your client really needs to be the person to sign a release. He hasn't signed a release for you to have the records?
No, this is for the complainant, Judge.
Ah, okay. Have you
I'm just
talked to?
anticipating the hospital's gonna give me a hard time because I want to subpoena the records.
All right, have you conferred with the state?
On the HIP order?
Yes.
No, I
All
just
right,
found it
if
yesterday.
you confer with them on that, and let's see where we are, and then I'll take up the writ after you confer with them.
Sounds good.
And have you conferred with them on the writ as well?
Last week.
All right, who did you confer with?
Kevin.
Okay, all right, thanks. Because with regards to that HIPAA matter, they may already have the records.
They don't.
Okay, all right, let's see where we are then.
Yeah, this is the one where I had to get the CPS records to figure out what hospital the child was born in. So
Okay.
now I know that, I'm gonna subpoena those records, but I just want to get the order.
Okay, all right, thank you.
One of us. Ready to jump the bridge. Long description. You know,
Sorry, I'm at my. I was like, wait, what are you?
All right, Von Skirvin,
Morning, Judge.
Good morning. Oh, I'm doing great. How are you doing?
I'm gonna go with good, not great.
Well, you know what? It's nice if you keep it at a certain level, then there are not too many highs, not too many lows. Let me just see where he is on the docket.
He's on the recall.
Okay, thank you. All right, so it's for cell phone downloads.
We have received them this morning.
All right, is there any other discovery issues?
I don't believe so, Your Honor.
And were they able to give you an offer or no?
It's Michael's case and we don't have. an
Oh,
offer yet.
Michael Villarreal. Okay. All right, Ms. Ferguson, can you reset this in 30 days?
Yes, sir. I can come back on the 24th.
All right, so we'll be back on January 24th, and at that time, the state will be able to make an offer to you.
Okay. Thank you, Judge.
You're welcome.
Signature. Yeah. Thank you.
Yes.
Just to have the recall from Tuesday. April. What is it?
Deputy Laura. Hmm? Yes. I don't know if we have the other ones for the entire group yet. Okay, all right. Okay, all right, I'll wait for it. Oh, Lupe will have it.
Oh, is that Bexar? From this, I need the thing, but from this week,
From the Capitol.
or from the Capitol? Oh, I have. Okay. Or I have the small one. Yeah. I have. You need it.
We'll see on April Apolinar, and then after that, Mr. Peddle, I'll take up your case. Who's here for April Apolinar?
And I think we're really close.
Yeah, the offer that was made the last time. Let me start from the beginning, Judge. They were asking for some mitigating information, which I provided, which caused them to modify their offer. And I'm asking for a further modification, which he needs to get caught up on, right? So if we could have this recalled on Monday to see if we can put a final nail in the coffin and get it done.
Well, let's not put a nail in the coffin.
Well,
How about if we could put a final flower in the bouquet?
Yeah.
there you go.
There we go.
One last bow.
Okay. Ms. Ferguson, on April Apolinar,
Yes, sir.
can we recall this for Monday?
Yes, sir.
She's on bond. All right, Ms. Ferguson, to give you a reset form. You're welcome.
Open my phone.
That's the one downstairs right here.
Yes.
Oh, okay. Got it. You got the small.
Did they get the reset form?
Which one?
No. you just walked
Oscar,
out.
could you grab Mr. Acevedo and tell him don't leave without the reset form? Thank you. Okay, all right, thanks. Brenda, once people leave, you're like, what? All right, the party's on Stevie Stokes. Brenda, you ready?
Yes.
All right, court is calling 2022 CR 8214, State of Texas versus Stevie Stokes. Can our parties announce for the record for the state?
Catherine Pollard.
For the defense?
Kelly Piddle.
And are you Mr. Stokes? All right, so the first issue we're going to take up is this matter of medical record related to Jalen Washington State. Do you have possession of those records or no?
Judge, I don't believe we do at this time. I believe we just got the information about which hospital we need to get those records from.
I discovered that from the CPS records when I looked last Friday that the child was born at that hospital. So it wasn't in any of the police reports, prosecution guides.
All right, so of course, as both parties know, the court knows absolutely nothing about this case other than he's charged with endangering a child. So based on your motion, you're saying that the court finds that this evidence is relevant and necessary. Who is Jalen Ray Washington?
It's the complainant on the case.
All right. And how is this relevant and necessary?
The child was born at 33 weeks, Judge, and was a preemie. And so I'd like to get the medical records from when he was born to see if there's anything there to be reviewed. This is the baby died at 2.5 months. So, and I think that its health is a main issue in this case. So that's why I'm asking for those records.
All right, state. All right, so I'll grant your order. All right, then the next issue we have is this writ seeking a bond reduction. State, have you had a chance to review that?
Yes.
And are you in agreement or no? All right, defense.
Just one witness, Judge. Benita Robinson.
All right, and if you'll step to that side. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. I'm gonna need you to make sure you speak up so that the court reporter can hear. State your name for the record.
I'm Benita Robbins.
All right, defense.
Thank you, Judge. Ms. Robinson, how are you related to Stevie Stokes?
Stevie Stokes is my son.
Okay. Are you aware of what his bond is set at currently?
Yes.
What is that at?
75,000.
Okay. And can you make that bond?
No.
What type of bond can you make?
I was hoping we can get it at 10,000.
Does Stevie own a car?
No.
Does he own a home?
No.
Does he have any money in his bank account?
No.
Okay, so he is indigent for purposes of being able to make a bond. Okay. If he were to be released on bond, where would he live?
You live with me.
Are there any minor children in your house?
Yes, one. She's 11. Sister.
Any concerns about Stevie being in your home with his sister?
No.
Stevie be able to find a job if he's released?
Yes.
And how long have you guys lived in San Antonio?
5 years.
I think that's all the questions I have, Judge. I'll pass witness.
All right, thank you.
Thank you.
Any other witnesses?
No further witnesses, Judge. We just asked to admit into evidence for purposes of this hearing. And it's exhibit 1.
All right, exhibit number 1, autopsy report is admitted. State, do you have any evidence to present? There are no police reports or anything for the court to review?
Judge, I can offer the office report.
Any objection?
No objection.
If you want to make a copy of those. All right, and then if you all would like to have a seat while I review the police report and the autopsy report.
Thank you.
Who's here on Cesar Vasquez? Thank you. Always good seeing you. All right, thank you. Do you have a detailed report on this? All right, if the parties can come forward on Stokes. All right, the court will the court has read State's Exhibits 1 and also Defense Exhibit number 1. neither party having any further witnesses or further evidence to present the court will hear argument with regards to the motion for bond reduction. I know the witness said the bond was at 75,000, but in your motion to reduce bond, you say that the bond is at 100,000.
I believe it's at 100, Judge, but I could verify it or the clerk can, but regardless of 75 or 100, the client's family can't make that bond. We're asking, is it 75?
Yes.
Okay, my mistake. They cannot make that bond. They don't have the funds. The clients, if he's to be released, is going to live with his mother. There will be no infant children in the house. He has no criminal history, as the state has not provided any evidence of that. And we ask that the court set the bond at amounts more obtainable for the client, so that he will agree to appear in court, as that is the purpose for bonds. And at an amount that's more commiserate of a state jail felony, which this is what this is.
Judge, we would just argue that given the nature of the case, the fact that the child died while under his supervision, and that he'll be going to a home with children living in it, that presumably he could be alone with there, having those children under his supervision, would just be opposed to reducing the bond.
And as the court reviewed the autopsy report, there's no evidence of any drugs or alcohol in the child's system. There's no evidence of anything in relation to how this child died. The child just died.
All right, and the court did review defense exhibit number 1, and it states that there is no trauma. And the court is just noting that for the record. All right, any other argument? All right, it's your motion. You can have final argument.
Judge, no further argument. Thank you.
All right, the court will reduce your bond to $50,000. There's to be no contact with Tremia, Washington. No unsupervised contact with minors. And defendant is not allowed to reside at any residence with occupants under the age of 11 years old. Are there any other conditions that the state will request? All right, is there any drug or alcohol issues with your client?
No.
All right, and Ms. Ferguson, this is coming back on February 9th. And state, if you all are intending to keep this as an endangering of a child or not, I'm going to need to know that on February 9th. All right, is there anything else?
No, Judge.
It's listed on here. It's for discovery. It's the CPS records, the 911 calls.
We have CPS, just waiting on 911.
Okay.
And I'm gonna subpoena these records. So.
All right, and I'm gonna see, you all have the autopsy, obviously.
Thank you, Judge.
Oh, just one second.
Sorry.
Yeah. So autopsy completed, you have CPS records received. And you just need the 911 calls?
Right.
State, do you have any idea on the 911 calls? Do you think you'll have them by February?
Yes.
If they're in existence?
Yes.
Okay. All right.
Thank you.
You're welcome.
Already, I was gonna say that before. One thing. Message. You're already way ahead of me. I even words are about, thank you.
Oh, yes. You're like,
before I forget.
Don't take the exhibit, Stephanie. You're welcome. Who's here on Jonathan Ben?
That's me, Rob.
All right.
I think that's, I think we're ready.
All right, if
I
you'll
don't know
come up.
which- It's Brittany's case, but I'm sure that somebody can step in if they're not. confirmed.
Oh, yes.
Also, just let you know the examples here, but,
Or which one?
I think it's the PSI, one of the PSI.
All right, I'm sorry. Could you have a seat? The interpreter's here and I want to, because we have a shortage and we'll pick that up right next.
Yeah, understood, yeah.
All right, thank you. All right, could I have the attorneys on Hector Laura Sanchez?
Sanchez.
All right, court is calling 2022 CR 3039, State of Texas versus Hector Enrique Laura Sanchez. Could I have parties announced for the record for the state? Defense?
Fernando Ramos.
And are you Mr. Sanchez?
Yeah.
Yeah. All right, I think that should be C if you were speaking in Spanish.
Oh. Sí.
Yes. Right. Can I have the interpreter if you could raise your hand? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Mariana Rios.
All right, so Mr. Sanchez, either you're going to use the interpreter or you're not going to use the interpreter. So do you, okay, so do you wish to use the interpreter?
Yes.
Right. You entered a plea of no contest on November 1st. And this is according to the plea bargain agreement. Punishment is to be assessed at a cap of 15 and the state is opposing your application. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Judge.
Any objections?
No.
No, Judge.
All right, state you're opposed. Do you have any witnesses?
No, Judge.
All right, defense, do you have any witnesses?
No, Judge. I have some exhibits.
All right. State, do you have any exhibits?
Just what's been previously admitted.
All right, defense, what are your exhibits?
2 exhibits, Judge, and possible third. State defendants 1 and 2. If I may explain.
Oh, just a moment.
Previously offered to ADA before I introduced him.
All right, any objections, state?
No objections.
All right, state, I'm sorry, the court will accept into evidence defendants exhibits 1 and defendants exhibit 2.
And they are, Judge, the defendants 1 is a translation of the interview of the complainant. She appeared to be more comfortable in Spanish, so they brought in a Spanish-speaking detective. And I've marked in, it's a short read, I've marked where she spoke to the detective. And the defendants 2 is the same nurse interview with the complainant.
Mhm. All right,
May I continue?
yes.
In both cases, Judge, she uses, for a 12-year-old, uses the terms penis and vagina in front of strangers. It gives you an idea of her maturity. And I believe she's a very elegant young lady. She is consistent in both interviews. And in fact, in the first interview with the detective, she states that she was never forced, never threatened, and that she voluntarily admitted to sex. According to the law, that makes no difference. But it could make a difference in punishment. The you're writing, Judge. At any rate, in the interview to the detective, in the last encounter she had with the defendant, she actually uses the word seduce, that she attempted to seduce the defendant.
But
Once
isn't she
again,
in
we're not
elementary?
trying to indict the complaint.
No, I understand, but isn't she elementary school age?
She's 12 years old, Judge, in the 7th grade.
Okay.
In this case, as the PSI reports, the mother, and I know my wife would have been upset had my child had sex with someone of that age, as any mother would. The mother says she's forgiven the defendant. She hopes that she doesn't spend much time in prison. We hope that you would acknowledge that there is a young kid in front of you. He's 23 years old, older than the complainant, but to us, he's a young kid. His whole life is ahead of him. If she had been a few years older, we wouldn't be here. In my review of all of the evidence, and especially having seen the interviews with her, and I have a copy of her interviews, not for the interview, but for the way she looks and how she presents herself. If the court wishes to see it, I know many times the court never sees a complaining witness unless they come to court and testify. This would give you an idea of how elegant she looks, how mature she presents herself, how unafraid she is to talk to a stranger detective about sexual terms. If the court wishes, I can introduce this as a part of the evidence.
Any objection?
I would affect that just based on the relevance.
It's part of the evidence, but was never introduced, part of the discovery packet.
All right, any other objections? All right, do you want to mark it?
Yes. I'll leave it in this little packet then.
Sure.
We offer defendants 3, Judge.
All right. State's objection is,
If the judge wants to take time to look at it,
yes. State's objection is overruled. Defense exhibit number 3 is admitted.
thank you, Judge. There's 2 views. Bear County, I think, does a good job. They have a view from a top and one at eye level.
All right, the court has reviewed defense exhibit number 3. Are there any other exhibits for the court to review?
Not from the defense, Judge.
All right, state any other evidence?
Nothing in state, Judge.
All right, the court will hear your argument.
Judge is very brief.
Oh, just 1 second, state.
Judge, defense has mentioned how elegant the 12-year-old complainant was and her mature vocabulary, but the defendant was well aware of the child's age. He told the detectives that the complainant's mom informed him of the child's age, and he continued to have sex with her. He picked her up from her middle school, where she was attending as a student, to go and have sex with her. When officers arrived at his apartment to find them, she was not clothed, hiding in his closet, indicating he knew very well that he was doing something wrong. Again, he claims that he was dating the 12-year-old victim for over a year by the time that he was caught. So the argument that he was unaware of her age or thought that she was older, she appeared older. It's irrelevant, Judge. He was having sex with this 12-year-old for a year, and we would ask that you deny his application and sentence him for the 15 years.
Judge Mack, may I respond?
Yes.
First of all, Judge, as I understood what the ADA has said, the defendant was not in the closet. The complaining witness was in the closet.
Yes.
Hiding. And secondly, as ADA has pointed out to me, at some point before the last arrest, there was a police call to, I'm not sure what the location was, but the police were called and the mother told the defendant her age. The complainant states they had approximately 4 consensual intercourses. So the first 3, we contend that he didn't know her age. She looks older than 12-year-old.
All right, so the 4th one, did he know her age?
She did. We cannot deny that.
And did he pick her up for middle school?
She called him, according to what I've read, she called him to pick her up. And I think it was an occurrence, happened often. He would pick her up at home and take her to school and just drop her off. Not stick
To middle
around,
school?
but just drop her off.
To middle school?
Yes.
Okay.
Whether he knew, he paid attention to other children that were there. Evidently, he did not. But it's true. He knew the last time he had sex. And that's when she said, she used the word seduced in the interview with the detective. Perhaps this defendant is from Honduras. I don't know if the laws are different. I'm sure they are. I don't know what the age of consent is in Honduras. For instance, in Japan, the age of consent is 14. I've read that somewhere. At any rate, there's no doubt that he's guilty of this assault. We would ask that because of his young age, he is under an immigration order to be deported, and he will be deported. We'd ask that you grant the application for deferred and allow him to return to his native country. Thank you, Judge.
You're welcome. Mr. Sanchez, is there anything you wish to say?
No, señora juez, yo en este momento.
Well, let me have you sworn in. Can you raise your right hand?
Oh.
May I preface, Judge?
Yes.
Mr. Laura Sanchez, you and I have talked about the term perjury. And you understand that if you lie to the judge or in a court proceeding, you could be charged with a very serious felony.
Yes.
So whatever you're going to say to the judge is going to be the truth. Is that correct?
Yes.
Thank you, Judge.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand, state your name for the record.
Hector Enrique Lara Sanchez.
Hector Enrique Lara Sanchez. All right, what would you like to say?
Yo en este momento voy a hablar un poco sobre lo que pasó con esta jovencita.
At this moment, I would like to talk a little bit about what happened with this young girl.
And let me just stop you for a moment. You're making a statement to me, but I want you to know that if you decide to make a statement to me, then the state will have a chance to cross-examine you or question you.
May I confirm, Judge?
Yes.
Mánsele de tu corazón, como sientas. Eso es todo. Thank you, Judge.
All right, do you wish to continue?
Sí.
Yes. All right.
En este momento yo, señora juez, yo le pido una disculpa.
At this time, Your Honor, I would like to apologize.
Nunca fue mi intención en hacer algo malo con ella.
It was never my intention to do something wrong with her.
Yo iba donde su mamá a comprar comida, era un cliente de ella que yo compraba comida ante ella.
I would go over to her mom's to buy food. I was one of her clients and I would go buy food from her.
Y en ese fue como yo la conocí a ella.
And that's the way I met her.
Pero nunca, en ningún momento, nunca supe su edad.
But never at no time did I find out her age.
Y yo, en este momento, yo le pido de por favor que si me pueden ayudar,
At this moment, I would like to ask you, please, if you could help me,
por favor.
please.
Yo, como le confesé a mi abogado, el motivo de poder llegar aquí a Estados Unidos
As I told my attorney, the reason for coming to the United States
es para ayudar a mi familia,
is to help my family out.
porque el motivo de salir de mi país fue porque tuve un accidente.
The reason why I left my country is because I suffered an accident.
Yo siempre con mi madre necesitaba comprar una medicina, pero no teníamos la capacidad para el dinero.
And I always needed to buy medicine for my mom, but we never had the availability to purchase it without the money.
Entonces, yo decidí emigrar para buscar una mejor vida para mi mamá, ayudarla y apoyarla.
I decided to immigrate in order to find a better life, to be able to help her.
Yo trabajo desde mi edad de 12 años para mi familia.
I've been working since the age of 12 to help my family.
Y el estudio que yo me di, yo trabajaba de lunes a viernes,
The education that I gave myself, I was working Monday through Friday.
sábado y domingo yo estudiaba en el colegio,
Saturday and Sunday, I would go to school.
pero pues lamentablemente pues en Honduras es todo privado, entonces ya yo mismo me daba mi estudio.
Unfortunately, in Honduras, everything is private, so I myself would study on my own.
Entonces nomás llegué lo que fue medio año de tercero de ciclo común.
And so I was only able to finish half a year of a common cycle.
Y pues por eso yo pido una disculpa y que si me puede ayudar, por favor.
And that's why I would like to apologize and to ask you, please, if you could help me.
Con el accidente que tuve mi mamá, pues quedó muy mal.
With the accident that my mom suffered.
Mi papá, pues igual tiene una, no sé si es hernia en esto de aquí. Pues igual necesito ayudarlo, apoyarlo para que él se pueda operar.
And with the accident that my mom suffered, she's not doing too good. And my dad as well, he has a hernia right here. And so I don't know if he needs an operation.
Y yo en este momento le pido que por favor, si me ayudan,
At this moment, I would like to ask you, please, if you could help me
me regalen una oportunidad.
to give me a chance.
Yo vine a este país no para hacer maldad.
I did not come to this country to do wrong.
Mi cultura es diferente,
My culture is different.
pero yo nunca, mi cultura es diferente la de Honduras a la de acá.
But I never, well, my culture is different between Honduras and here.
Yo trabajaba aquí en lo que es el escaping.
I was working here in what's known as landscaping.
Nunca tenía una novia hasta que la conocí a ella.
I've never had a girlfriend until I met her.
Y pues con ella pues estuve hasta el tiempo que estuvo.
And with her, I was with her until the moment that I was with her.
Nunca pensé lo que me podía pasar porque pues en mi país pues es diferente mi cultura.
I never thought of what could have happened to me because in my country, Honduras, the culture is different.
Y pues yo le pido de por favor, si me pueden ayudar, por favor.
And I ask you, please, if you could help me, please.
Este momento que he estado aquí encerrado
This time that I've been here locked up,
ha sido muy difícil para mí.
it has been very hard for me.
Somos seis en familia,
There's 6 in the family,
8 por todo con mamá y papá.
8 in total with mom and dad.
Pero este tiempo ha sido difícil en la manera de que yo los ayudaba a ellos para la comida y cualquier cosa, sagrados alimentos, todo.
But it's very hard for them. It's been very hard because I'm the one that was helping them out to purchase food and stuff.
Porque desde que llegué yo no tengo ningún ahorro, nada más que mi dinero que he ganado lo he invertido en ellos.
Because ever since I got here, I don't have any savings. All the money that I've made, I've invested in them.
Y yo le pido, señora juez, de por favor, si me puede ayudar en esta ocasión por lo que estoy pasando.
And I ask you, Judge, if you could please help me out through the situation that I'm going through.
All right, state.
Just a few questions, Judge.
Judge, we would object to any questions by the state. The defendant has only stated peripheral facts about his life, about his family. We would object to any cross examination by the state.
All right, that'll be overruled. And for the record, when the defendant entered his plea bargaining agreement, he gave up the right to remain silent. Let me ask you a question.
You said that when you came to this country, you didn't come to do any wrong. Do you think you've done something wrong?
La verdad, dentro de mi corazón, siento que no he hecho nada malo.
The truth in my heart, I feel that I haven't done any wrong.
You claim that you didn't know the victim's age, correct?
Sí.
Yes.
But you told detectives you did know her age. Correct.
Es perfecto, pero yo vine a saber su edad hasta cuando me arrestaron.
That's perfect, but I came to know of her age when I was arrested.
So why is it that you told the detective that you knew of her age, and then you continued to have sex with her, correct?
Sí,
Yes.
yo nunca pensé tener un problema así,
I never thought I was gonna have a problem on.
porque como le digo, pido una disculpa ante todo, ante la juez, personas que están a mi alrededor, ante el abogado.
As I said, I apologize to the judge, to everybody around me, to the attorney.
Pido una disculpa.
I apologize.
Porque mi cultura es diferente en Honduras a la de acá. Yo nunca pensé tener el problema por lo que me causaron.
Because my culture is different between here and Honduras, and I never thought that I was gonna have a problem, the problem that was caused.
So you say the difference of culture, but you knew what you were doing was wrong, right?
En el momento,
At the moment,
el momento, yo sabía que era su edad, pero nunca pensé tener problemas. O sea, nunca pensé lo que me iba a pasar.
but at the moment, I knew what her age was, but I never thought that it was gonna cause any problems. I didn't know what was going to happen.
Entonces,
Why is it that you told her to hide in the closet when the police were there if you didn't think that you were doing anything wrong?
perfecto.
Perfect.
Cuando la policía llegó al apartamento,
When the police arrived at the apartment,
yo espero y me entiendan y me comprendan.
I hope you understand and understand.
Yo salí a la sala,
I came out to the living room,
pero salí vestido.
but I came out dressed.
En ningún momento me he negado, en ningún momento he dicho mentiras.
At no time have I denied myself. At no time have I lied.
Desde que estaba con el detective, yo siempre dije la verdad.
Ever since I was with a detective, I always told the truth.
Cuando yo salí para afuera, a lo mejor ella tuvo miedo y se escondió en el closet,
When I came out, maybe she got scared and hid in the closet,
pero yo no la escondí en el closet, ella se escondió en el closet.
but I didn't hide her in the closet. She's the one that hid in the closet.
Y yo pues espero y me entiendan y me comprendan porque pues en ningún momento me he negado la verdad, lo que pasó.
I hope that you can understand me because I've never denied myself as far as what happened.
Judge, I have no further questions.
Any other questions?
Of you, Judge. Mr. Laura Sanchez, the complaining witnesses said approximately 4 times you had sex, is that correct?
Sí,
Yes,
And it was only the last time that you knew her real age, is that correct?
sí,
yes,
Did she appear to be older than the age that you eventually found out that she was?
sí,
yes,
And when you say that you don't think you did anything wrong, is it because she voluntarily engaged in sexual intercourse with you? Is that correct?
sí,
yes,
You never threatened her?
no,
You
no,
never forced her?
no,
no,
And she always willingly accepted your advances?
sí,
yes,
And on the last occasion, she actually said that she made advances to you so that she would have sex with you.
yes.
Go ahead, young. Ask wishes.
All right. This is what the court is going to do. The court is going to deny your application, find you guilty, sentence you to 15 years in prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent, and Chapter 62 registration. Did you review the document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? And did you understand it?
Yes,
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes.
All right, good luck to you. Thank you.
Have excuse, Your Honor.
Yes, thank you.
Thank you, Judge.
All right, do you need me to sign anything? Do you need me to sign anything? All right, thank you so much. Bye.
I'll get it.
I apologize.
No problem. And Brenna.
This one.
And can I see the parties on Jonathan Ben?
Judge, I'm here. Where is the? Yeah. I usually tell people not to move around the
Oh, no,
courtroom
come.
unless the judge orders you. That's a pretty good reason.
Right, the court is calling. Oh, you ready?
Yeah. I'm ready.
People move things around, so now I have to lean over to see you.
Let me skip over.
Okay, court is calling 2022 CR 10909W, State of Texas versus Jonathan Price. Can I have parties announced for the record Jonathan Pierce Ben. Can I have parties announced for the record? State?
Daniel Escobar for the state of Texas.
And Andrew Fred for Mr. Bean.
Oh, it's Bean?
Yeah, spelled Ben, pronounced Bean. I
Okay.
get that a lot.
No, I'm glad I've been corrected. All right, we are here. You entered a plea of no contest on November 16th. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
Any objection to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, Mr. Bean,
Yes.
according to the plea bargain agreement, the state is opposing your application for community supervision or deferred adjudication. Are there any witnesses from either side, state?
None from the state.
My client wishes to make a statement, Judge. I don't know if that is what your question is specifically.
Yes. Is he your only witness?
Yes, Your Honor.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. And have you been retained?
Appointed, Your Honor.
Appointed, okay. Because it has on here that Andrew, oh, you are Andrew Prolick. Brandon,
Last I checked, yeah.
I was envisioning somebody different and I'm like, no, Andrew
I'm
Prolick.
not
is
sure whether to be insulted or I mean, thank you. Appreciate that.
Brenda, it is truly, yeah, it's truly Friday, because I was like, wait a minute. Okay.
Fine.
Just want to point out I'm wearing a different tie than I usually wear.
See, that's what's throwing me off.
Is that what it is?
Yeah, it's the best of times.
It's the best tie. I should have worn a purple tie for you.
See, yeah, then I'll be like, oh, that's Andrew Floyd. All right, Mr. Ben, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand. All right, Attorney Froelich.
Thank you, Your Honor. Mr. Bean, you and I talked for a little bit earlier, correct?
Yes.
And you wanted to point out to the judge that I'll be frank with you, you've been stealing for as long as you can remember.
Yes.
And you have more convictions for theft than I can possibly count.
You can use my hand. Yes.
Yes, a lot. Let's just say that, right? But we were talking and you applied for probation and you were asking this court and telling the judge that this time is different. And you and I talked about this for a while, for a few minutes. So I want you to tell the judge, you told me, why is this time different than the previous times? And you can take as long as you need.
Well, with age, they say comes wisdom. And the last stealing that I had been caught for was a tiny split shy of a decade. And from stealing since the age of 2 till now.
I'm sorry, you said stealing since the age of 2 years old?
It's one of the very first memories I have as in existence, of a person. The only other thing that I can think of that's lasted longer is my art, in regards to being that long active in it.
So let me pause right there. So you take full responsibility for this.
Yes.
And you're not blaming it, and there's a TAP evaluation that was done. You're not blaming it on the fact that it was drugs or anything like that.
No.
It was just a bad decision you're taking full responsibility for.
Yes.
But I want to pivot again, because you told me again, and the judge has a great thing that she does about how stealing, just don't do it. Like don't do it. It's wrong. But this time is different. And you feel like you could do probation. You tell judge about why this time is different.
Because all the stealing that was prior to this incident, I used to steal for profit. And I had convinced myself on this particular occasion that if I'm stealing because I'm hungry or for the camp, then I was just fine in my own mind that as long as it's not for profit. I kind of glamorized the people in the movies, Robin Hood, Whoopi Goldberg and Burglar and all, where they're stealing, but they're the good guys, and I tried to put myself in that position.
So you're
even
saying
though
you stole like Robin Hood and gave to the poor? Is that what you're telling me?
Well, I was totally broke at the time, and I was.
So you stole and gave to yourself?
Yeah, I was the poor.
Okay.
And it's not a justifiable excuse, because it's not like when The Simpsons where Nelson said stealing is like punching somebody in the dark, because it's a victimless crime if you're doing it from a store. And I know for a fact that that's a lie, because I've been doing it for so long.
Okay, I remember that episode, but okay.
And if you say I go into a store and steal something, they're going to tax it to the people that go to that store. If I steal a bicycle, you are now paying 2 or 3 pennies more for a milk, because they're making up for what I do.
But you got that realization since you've been in custody.
Well, I've had it for a while, unfortunately. Some old habits die hard, and when you're not comfortable with something, you fall back on what you are comfortable with and what you know to do, and you do well. I'm not good at flying signs. I'm not good at panhandling, and I've never really been good at asking. But one thing I had been very good at over a course of decades was testing my ability to circumnavigate.
Are you not good at
security.
applying for jobs?
When I do work, I work so well that whenever I go back to that job, they always rehire me because I do subcontract.
So when a job comes and they hand me a paycheck, I got into a party mode. And I would hold up the paycheck they would hand me, and I say, when this is done, I'll be back. If there's work, great. If there's not, no hard feelings. And I'd worked so well at these jobs that when I come back, they would always rehire me
Mhm.
because my work ethic's real strong. My problem is at the time, I will take a legal opportunity, but I will take an illegal opportunity just as quickly as I will take a legal opportunity and apply the
So
part.
the force is strong with you for theft.
Yes.
But this time is different. Can you get to the part where this time is different, Mr. Bean?
Yes.
Because you and I talked about this extensively, and you said, I know how this time is different because you've been doing this for so long. You said, old habits die hard, you're not helping yourself. What we talked about was this time is different because this time you have a plan. Can you tell the judge that part?
Yes.
Thank you.
I've been doing the in and out of prison for a long time. And it's all been stealing stuff. I've come to the realization this time locked up from taking a class. Last time I'd gotten out on February 11th of this year. And I didn't get locked up till November 1st of this year. Since 17 till now, and I'm 47, that's 30 years. This is the longest time that I've ever been free as an adult. And the key thing was that class that I took when I was locked up. It taught me one thing, and it harped on it over and over and over. Putting yourself in another one's shoes, empathy. I knew from a young age, and I kept using this particular thing, which is to turn off one's empathy, to basically turn off your conscience, the little angel and devil on your shoulder. I turn off the angel. And I learned that to turn it on and keep it on. And I think that will be a key asset in the change that we're talking about. Plus the fact that all the resources that are available, I've had access to all these all the time. And I'm not utilizing any of them to their full potential to help me. And if I had empathy, plus these resources to their fullest ability, you won't see me in your courtroom again.
And Judge, that's what we're asking for. If we give him a chance on probation, you still have that full range of punishment available to you if he messes up. So what we're asking for is for Mr. Bean to take that empathy. Remember, he talked about the added pennies that the price of your milk and everything else goes up because he steals. I think the added empathy goes up in this case. I think he has a different change. I think that if you have the full range of punishment, he'll show you he can be successful. He has access to the resources he talked about. He talks about how he can go to Haven for help. He talks about the access to the resources for his mental health situation. He knows that he can now go out and work at places which he has been unable to do before. But Judge, if you give him an opportunity, he will have the chance to prove you right. And you'll still have the jurisdiction. You'll still have the ability to bring him back in here and sentence him if he does mess up. But if he doesn't, he has access to resources to be successful with the programs we can provide in Bexar County. They're different. The one thing that we are asking for is an opportunity. And I'll be frank with the court. I'll say that, I'm sorry. One thing you need to correct real quick. It's not only for stealing. You have been in prison for other things. Do you want to address that before the prosecutor hammers you with it?
Well, just like.
Well, I've seen your criminal history. State, do you have any questions?
I was gonna ask, sir, it hasn't only been for that, has it?
No.
What else was it for?
Well, just like the last case, it hit home pretty hard because.
No, he's asking
what was the charge?
It was exposure.
Okay, and you have had a chance to look at the PSI report, correct? Yeah, so I was able to count, there have been 9 theft convictions. So, pretty good hands.
All right, this is what the court is going to do. The court is finding you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Oh, yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Ben, I appreciate the fact that you have decided to change your ways and change your life. But your criminal history, sometimes a criminal history is like a credit report. And so I'd look at all the chances that you've been given. I saw where you're on probation for burglary and that got revoked. And then you were given other chances. So when you go to the state jail facility, internalize and think about how you got here and then change your ways so you don't come back here again for this. You understand? All right, good luck to you. I want you to let you know that I heard what you were saying and I internalized it though, okay? All right, thank you, Mr. Ben.
Sorry about the milk. I'll fries.
No problem. All right, you two, who's here for Angelica Gonzalez? All right, what is happening with this case?
We have concurred with the state, Oscar Sims, I'm not sure, and they are allowing her to apply for the PTD program.
All right, Ms. Ferguson, can I have a PTD date on Angelica Gonzalez?
Yes, sir.
All right, we'll be back on February 13th. Make sure that everything is filled out before then.
Yes, Your Honor.
All right, Ms. Ferguson will give you a reset form, then you're excused.
Thank you very much.
You're welcome.
Yeah.
Oh, no, no problem. Thank you. You're welcome. All right, you too. Brenda, people tell me I have patience, but I'm like, do I really?
Yes, you have lots of patience.
Judge, would you like to see my, she ended up being a camel, but my shepherding camel.
Yes.
Well, there's Charlie and there's
Aw.
Hannah right there. So cute. Yeah, that's adorable.
Well, I'm glad that's her role in the play.
I'll walk them off.
Oh, that's awesome.
Oh.
I said that's awesome, but I can't sit without my glasses. That's so cute. Thank you.
Like, let me see that again.
So now I can say it's awesome and
Done.
truly mean it. Yeah, I can't see without my glasses. What's here on Henry Peterson? Yes.
That's just the order that resulted from the hearing we had on Tuesday. Court asked me to- Thank you, just.
Leo Gonzalez.
Morning, Judge.
Good morning. And where's Leo Gonzalez?
Judge, Leo texted me this morning, said he's out for a funeral. For, one of his family members, and then I texted him back, I asked him for some more details, he hasn't returned the text, but then I texted him to see if he could come in tomorrow. I'm gonna leave that up to you.
All right, he was late previously.
Okay.
So I will have him, I'll recall him for tomorrow. If he doesn't show up tomorrow, let him know a warrant is going to be issued and let him know that tomorrow he needs to bring proof that he was actually at a funeral. And when I say a funeral, I don't mean some stranger's funeral where he's just walking to a church and grabbing a program. It had better be someone that he is related to or that he personally knows.
Absolutely.
Okay. All right, Ms. Ferguson, we're going to recall Mr. Gonzalez for tomorrow.
Yes, sir.
Thank you.
But I had a second one on Armando Rodriguez.
Just 1 second.
You don't mind.
Who's here on Armando Rodriguez? I'm going in order in which I got the files.
That's one
All right, yes. Where's Armando Rodriguez?
I have no contact with him, but
All right, we're going to go on the record Court is calling 2022 CR 10589, State of Texas versus Armando Rodriguez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Robert Galna for the defendant.
All right, this hearing was scheduled at 9 a.m. is now 11:13 a.m. Defense, have you had contact with your client?
I have not yet.
Deputy Laura, was Mr. Armando Rodriguez announced?
Yes, he was not answering. He was not.
All right, state.
Your Honor, state moves for a bond for a warranty issue for the event as well.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
You're welcome. This is a plea. Who's here on Melanie Flores?
Judge, that was Jeffrey. Upstairs. Judge, he's here.
All right, court is calling 2022 CR 10638, State of Texas versus Melanie Flores. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For defense?
For defense, Jeffrey Martinez from Ms. Flores.
All right, the people in the jury box, I'm gonna have to ask you to be quiet while we're on the record. Or Deputy Laura, could you move them to the other end perhaps? And are you Melanie Flores? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, we did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Flores, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Flores, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it at all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with the government record, defacing or harmful? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Not this time.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did
Yes.
you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There are no applications. This will run concurrent with, is that 2019? Has she already been sentenced in that case?
She has one.
All right, this will run concurrent with 2019 CR 6398, County Court Cause number 609260. The state will take in consideration 2022 CR 10637, County Court Cause number 691339, Grand Jury number 783068. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That's all, that's the agreement, Your Honor.
State?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence?
Your Honor, state offer states to the one in all attachments.
Your Honor, defense has no objection.
Ms. Flores, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just we'd like to follow the plea agreement as made.
All right, the court will sentence you to 2 years in prison, give you credit for any time served. This is the right concurrent with 2019 CR 6398. County Court cause number 609260. Take in consideration grand jury number 783068, 2022 CR 10637, County Court cause number 691339. Is there anything else from either side with regards to sentencing?
No. No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms. Flores, you're going to have to make a decision in your life, whether you want to keep on this path in and out of prison or not. And you need to start by asking yourself, as you're serving your 2 years, was this worth it? And usually the answer is no. Because people want to be out in the free world, right? You're gonna have to start making better decisions. All right, good luck to you. Who's here on Leroy Settles? Leroy Settles.
Oh, yeah, now I remember.
Oh, I'm sorry. Yes.
Is that the one with Lauren Lefton? Is that Lauren Lefton?
Oh, yes, it is. She's supposed to be coming back. Thank you. Who's here on Carlos Romero?
We are.
All right, come forward.
For a motion for a bond reduction?
Just give me a moment. The court reporter is taking a short break.
Okay.
Who's here on Angelica Gonzalez?
Oh, yes, I am.
Megan.
Okay, thank you.
That's about what we're looking for.
Okay. All right, Oli Thomas, is he on bond or in custody? All right, can you let him know that's gonna be recalled for the 16th? His attorney's in trial.
He just came in and left.
No problem. Morning, good morning. Who's here on Curtis Odell Williams? Yes, where's your client? Is he here?
That's the one that Angelini has to be here. That's the one that was.
Ah, okay.
How do you get that?
Hello, hi. How are you? Yes, so where we're in discovery?
So Judge, on Monday, this case was reset to today, or was it?
No, it was yesterday.
Yesterday. So I did upload the Coban. We were waiting on a fingerprint card. That's something that our investigator has been out of the office the last few days. So I have to get a contact. So that's what we're waiting on.
All right, how long is that gonna take?
Probably I'd say a week for him to reach out, especially with the holidays, and then to get a response depending on if the people are in.
All right, Norm, we're gonna do discovery for this in January. What date? Do the 3rd week in January, so that could be done by that day.
No, I understand. Your Honor.
Okay.
And again, we uploaded Coban, I think, while we were in docket on Monday, so that's already taken care of.
Okay, awesome.
I can do the 19th.
All right. All right, and I'll have, since Judge Angelini allowed your client to be excused, I'll have your client excused for the 19th, okay?
Thank you, Your Honor.
All right, you're welcome. All right, who's here? Mark Reyes.
I'm present and ready, Your Honor.
All right, where's your client?
He's in custody. He's right here.
Oh, let's bring him up.
All righty.
And then after this, we'll take your client. Is he going to enter a plea on this today?
He's going to enter a plea of not guilty.
All right. Court is calling, and Ms. Ferguson. On this, then, we're going to need a contested hearing set.
Wait, what did I say? Did I say
You
not
said
true?
not true.
Oh, no, I meant true. I'm sorry.
What
did you say?
I'm
I was like, okay.
I don't want to say senior moment because I think that's
It's already
premature.
happened to me. I saw Andrew Folick and I was like, excuse me, are you retained? Because the person listed here is Andrew Folick. He's like, I am Andrew Folick. All right, the court is calling 2020 CR 10202 State of Texas versus Mark Reyes. Could I have parties announced for the record for the state?
Oscar Salinas for the state of Texas.
For the defense?
Lorraine Ephraim for Mr. Reyes.
And counsel, can I see it for a moment? And are you Mr. Reyes?
Oh,
Yes, ma'am.
Mr. Reyes, did you have a chance to review with your attorney what's entitled motion to enter adjudication of guilt and revoke community supervision?
Yes,
And
ma'am.
first amended motion to enter adjudication of guilt and revoke community supervision?
Yes, ma'am.
Are you the same Mark Anthony Reyes who was placed on deferred adjudication in 2020 CR 10202 for the offense of unauthorized use of a vehicle on May 4, 2021 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, violated condition number 5 in Bear County, Texas. The defendant, Mark Anthony Reyes, did then and there fail to report the supervision officer as directed for the month of October of 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State,
State waives the remaining allegations.
any objection to the waivers?
No, Your Honor.
Mr. Reyes, did you understand by pleading true to violation? Sir, you need to take a seat. Yes. All right. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge.
No.
Oh,
No
there's not.
agreement.
Oh, I'm sorry.
Sorry.
I misunderstood, Daniel, then. My apologies, Judge. There's
Maybe-
not an agreement.
Maybe I didn't communicate it.
All right. So state, what are you requesting?
Okay, the state would ask this court to grant the motion, revoke defendant's community supervision or deferred adjudication and sentence him to 18 months in the state jail facility.
All right, defense, what are you requesting?
Your Honor, Mr. Reyes would like an opportunity to be reinstated or continued on probation. And I think he would like to address the court directly if that's okay. His situation has improved dramatically. That's one main thing he wants the court to know, and he thinks he's in a much better position now to be successful on probation than in the past. He does owe, from what I understand, quite a bit of restitution on the case.
$8,000.
And he believes that he can be gainfully employed here, that he has a job waiting for him. And he wants to and intends to at least make some progress in payments on the restitution. I don't think anything's been paid to date.
And the court wants the restitution paid.
Yeah. But Mr. Reyes, is there something that
You
you
want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. What would you like to say?
I just want to say, as far as the probation when not reporting, I don't know if you remember, whenever I got probation, I was living in Atascosa County, in Lido, Texas. So there was no way I was able to hop on a bus and go report
and go do drug tests all in the same day. But now I do have a place to stay here in San Antonio. I have a job waiting for me when I get out. And I just have a better environment now. That's all I want. For the court to know.
Where would you be employed, you believe?
I do have an electrical apprentice license. I gained that when I was on probation. And somewhere in the electrical field.
Yeah, I don't understand your saying about the reporting, because I ordered regular Zoom reporting or in person, so you can report by Zoom or in person.
Yeah, well, there were several times that my probation officer wanted me to meet with him in person, not through the Zoom.
Okay. All right, State, do you have any questions?
No, just arguing.
All right, so with regards to the $8,000, if I were to continue you, how much money is he going to be paying towards this $8,000 that he owes?
Well, he's been in custody for about 200 days total. So at this time, I don't think, do you have any funds that you could pay down?
I actually do. My girlfriend, I don't know if this matters, but she had gotten into a car accident recently and the insurance had granted her some money. And
Oh, you shouldn't be using her insurance
no,
money.
I have stimulus checks coming in.
All right, so here's the thing.
Yes, ma'am.
I don't think people should be using other people's insurance checks to take care of themselves. That's for that person.
Yes,
And I
ma'am.
don't think you should be asking for that, because you need to pay that, because
I
otherwise
do.
you don't learn your lesson.
Do you actually have stimulus checks waiting for you?
They should be hitting any day now.
You're
according to the-
expecting them?
Yes, according to the H&R Block, my girlfriend has my debit card and
I didn't get a stimulus check.
I'm getting 3 of them.
Well, I don't even think you should mention you're getting 3. I'm getting 0. I got
sorry.
0.
Well, how much would you be able to pay down towards that restitution? Do you think you'd be able to pay 500
I'll
or
be able to pay
1,000?
more than, I'll be able to pay $1,000, ma'am.
All right, State, what are you requesting?
At this point, still revocation, Judge. If you made an agreement with this court to be on supervision, has violated that agreement. And again, the court pointed out correctly that one of the easiest things being on supervision is to simply report, and even gave him the opportunity to report via Zoom. He failed to do that. Again, he's stating that there was requirements to be made in person. However, I don't know whether that was conveyed that he was unable to. But again, you have someone who's on probation who is clearly demonstrating that he's not a successful probation.
Right, is there something you wanted to add?
Oh, Judge, he was reporting on Zoom. The last appointment was on September 17, 2021, in which his officer indicated he needs to take probation seriously. Mr. Reyes at that time then said it's all too much for him. He just don't want to do his time.
Okay.
He may have said that in frustration, but he's been in custody now for almost 6 months, maybe 200 days, but it's a little over.
All right, so I'm gonna give you a choice. Sometimes I can give people choices, sometimes not. And the only reason why I'm giving you this choice is because there's $8,000 that's owed to Mr. Garcia. And Mr. Garcia needs that $8,000 to help make him whole. So I can give you the 18 months that the state is requesting, and you'll get credit for any time served that you've been in custody. Or I will continue you. I'm going to extend you, and you're going to pay that money. And if you don't pay that money, we're going to be right back here again.
May I speak?
Yes.
I would want to get reinstated. Continue, please, ma'am. And like I said, I do.
Continued and extended.
Yes, continued and extended, and I will pay that money. And report. And I will be living in Bexar County city limits, so I'll be able to get there. If it's needed to be in person, you know.
And the record reflects.
Yes, ma'am. Yes, ma'am.
Made a statement that there's
I'll do it.
income that's coming that's outside of his normal income, that so there's the income that should be paid towards restitution.
Okay.
I'll do whatever it takes, Judge.
All right. The court will deny the motion, extend you for 1 year. When are you going to have this $1,000 lump sum?
as soon as the money comes in, like I said, my girlfriend,
Do you
they,
think within 10 days?
within days, within 10
Within-
days, I
you
will say
think
10 days.
10 days?
Yes, ma'am.
But
All
then
right,
we'll put it-
$1,000
Or
restitution.
by December 31st, maybe? Today's the 15th.
All right, no, this is what I'm gonna do.
Okay.
There's $1,000 lump sum to begin with towards restitution. That is to be paid no later than January 9th.
Okay. That's it. Thank you, Judge.
And then thereafter. How much are you able to pay per month?
Or as
No. It's a figure.
I can pay, what is $100 okay? 100, 200?
No. How much are you expecting to earn from your job?
Oh, okay. Well, I'll probably be getting about 600-700 a month. Every paycheck.
Is that every 2 weeks? Or every
That'll
week?
probably be every week.
All right, you're gonna pay $250 per month
Okay.
towards restitution. So probation, he's to pay $1,000 towards restitution by January 9th. Thereafter, he's to pay $250 a month to restitution. I'm gonna want weekly reporting by Zoom until further notice. I'm gonna want him employed within 15 days of release. Again, no employment as a home health care provider or with minors. I'm gonna want field visits one time per month until further notice, and probation, if they want to count that field visit as reporting, they can. And I want the restitution prioritized. All right, is there anything else from either side?
Your Honor.
All right, thank you.
Thank you, Judge. May we be excused?
Yes.
Thank you so much.
You're welcome. All right, Carlos, yes.
We're ready.
All right. Have you all conferred with the state?
Well, Judge, we don't really know who to confer with.
Mr. Salinas? Because this is a burglary of a habitation, and they're asking for a bond reduction. All right, so if you all can confer with him. Who's here on Leroy Settles?
I am now.
Oh, just have a seat. Court is calling 2022. I'm sorry, if you guys could confer away from Brenna, that's okay.
Sorry, Mirna, I'm sorry. Sorry.
We're, I need to put a force field around
I
you.
need like a.
All right, court is calling 2022 CR 10419, State of Texas versus Leroy Settle. Can I have parties announced for the record for the state? Oh, your client showed.
Yes, that's why I asked to approach on them. So I was letting the court know if you had
Oh.
already issued the bond forfeiture.
All right, no, I have not issued it. Do you want to confer with the state?
Yes.
All right, thank you.
Okay, thank you.
All right, they're ready on that.
I apologize.
Oh, no problem. Melissa Carlson.
That's mine, Judge.
All right, we're here for discovery. So have you received all of the discovery or no?
I need the state to give you an update, Judge.
Yes, discovery on Melissa Carlson.
Judge, I reached out to the detective who was in charge of the case. He indicated that he thought that he had written more police reports on this matter to give more information. When you look back, you realize that he hadn't, so he was gonna go through the evidence again and actually catalog everything. That was around Thanksgiving. He recently told me that he'd been sick with COVID for about a week or two. And so he's just returned to work earlier this week.
Okay. All right, Ms. Ferguson, can you give me a January date, the fourth week in January for discovery? Yes.
Thank you, Judge. Maybe we
No,
can excuse
we
that,
haven't
please.
gotten the date yet. No.
26.
All right, Ms. Ferguson will give you a reset form. We'll see you back on the 26th at 9 a.m.
Yes, ma'am.
Thank you.
Thank you, Judge. Yeah.
Who's here on Harold Esther? Mr. Esther, come on down. Court is calling 2021 CR 7572, State of Texas versus Harold Esther. Can I have parties announced for the record for the state?
Oh, Oscar Salinas for the state.
Defense?
Eric Hernandez for the defendant.
And are you Mr. Esther? Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Harold Floyd Esther who was placed on community supervision in 2021 CR 7572 for the offense of burglary of a building on August 30th, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Judge, but violated condition number 1 on or about the 14th day of November 2022 in Bexar County, Texas. The defendant Harold Floyd Esther committed the offense of possession of controlled substance penalty group 1 in violation of condition number 1.
How do you plead to that? True or not true?
True. And violated condition number 1 on or about the 14th day of November 2022 in Bexar County, Texas. The defendant Harold Floyd Esther committed the offense of criminal mischief in violation of condition number 1.
How do you plead to that? True or not true?
State waives and abandons remaining out of this.
Any objections?
No, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion and sentence you up to 2 years in the state jail facility and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find 1 and 1 true. Is there an agreement?
No, Judge, there's not.
All right, state, what are you requesting?
The state's asking that you revoke the defendant's community supervision and sentence him to 24 months detention.
Defense, what are you requesting?
Your Honor, Mr. Esther is requesting reinstatement. In the alternative, he's asking the court if you would consider his testimony and reducing his sentence from 24 months to something lesser.
All right. Mr. Esther, what have you done on probation other than pick up new charges?
Oh, basically, I did community service hours after I community service hours with Salvation Army.
Why are you picking up new charges?
I had no excuse, Your Honor. I lost my mom while I was in jail. Last time I was locked up or whatever. So I'm still dealing with it. No.
All right. State, what is going to happen with these new offenses?
State will be TIC.
All right. And do you have the TIC numbers for the court?
Not at
No.
the moment, Judge, but I
Okay.
will right now.
That's okay. Let me see if it's on the system. Just 1 second.
I have the night mag from your court, Your Honor. I do not have the County 6 case number.
All right, let me see what page he's on because it should be listed on the docket.
Who are you looking for?
Esther, where is he?
He's on page 35. I think you are. Here you go.
Oh, I see it, but do you have the cause numbers? All right, thank you. Thank you. Yes.
Yes, thank you. So
Say-
on the night mag is 687466, and that's for less than a gram. And the criminal mischief is out of County Court 12, that's 696879. There's a complaint in that one, of course, the state would ask that restitution, if any, be placed on as a condition of this parole. And I had the name and I just forgot. Price and number.
All right, this is what the court is going to do. The court is going to grant the motion. The court is going to sentence you to 1 year in the state jail facility, give you credit for any time served. Taking consideration night mag number 687466. County Court Cause number 696-879. There's to be restitution, if any, in 696-879. There's to be no contact with San Antonio Independent School District properties or functions. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, you have a right to appeal as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You need to do better. You understand?
Yes, ma'am.
All right.
And I'll submit the dismissal.
All right. Oh, okay, thank you. Who is here on David Sanchez? Court is calling 2022 CR 8977, State of Texas versus David Sanchez. Could I have parties announced for the record for the state? Defense?
Everett Stantonburg for the defendant.
And are you Mr. Sanchez?
No.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sanchez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it? All right, next I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Sanchez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that you're charged with the offense of burglary of a habitation with the intent to commit assault, which is second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State recommends community supervision. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of the plea?
Yes, Your Honor.
Defense? State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There be 200 hours of community service restitution. No contact with Genesis Inostroza, Inostroza, and the BIPP Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Judge, the offer was marked as states that one.
No objection, Your Honor.
Mr. Sanchez, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We hope that you will follow our plea agreement.
All right, Mr. Sanchez, why are you climbing up a second-story balcony?
She got to me.
I
It was
mean,
a bad day, he told me, and he is so sorry that he made that rash decision.
do you have any children?
No, ma'am.
Are you employed?
Yes, ma'am.
Is there restitution owed to her? Because my understanding, he took her phone, threw some items off the second-story balcony.
I don't have any restitution amounts to know.
I didn't see any.
All right, how are you supporting yourself?
He's a good job.
Yeah, what do you do?
I do demolition. I drive excavators.
How long you been doing that?
6.5, around 7 years now.
How much money are you making?
Exact, not sure. I'm making 18 an hour,
Okay.
40 something, 40 something hour. I mean, every week, 40 something hours every week.
Do you live by yourself?
Now my parents,
How long have you been living with them?
my whole life. We've been at the house for about 20 something years.
And do you support them? You
Yes.
pay towards the household bills?
I give them money, yes,
All right, do they want you staying with them?
yes.
Are you planning on remaining living with them? Or are you gonna eventually move out on your own?
Eventually move out,
How old are you?
27, 26 actually, a lot of it 27.
Okay, and when are you planning on moving out?
Soon, whenever I get everything situated.
What does that mean? What
I
is
just
soon?
want- I just want to see what happens with this before I start spending money somewhere else.
Oh, well, this, you're gonna be on probation. So when are you planning on moving out from your parents?
Not anytime soon.
What'd you say?
It's not anytime soon.
Not anytime soon. I didn't know if you heard it.
No, I heard it. I mean, I'm just amazed by adult people continuing to live with their parents and then doing foolish things. This is what the court is going to do. The court is going to sentence you to 5 years in prison, suspended and probated for 5 years. There's a $1,500 fine. That will be probated. There's an affirmative finding of family violence. There's to be no contact with Genesis in Astroza, the BIPP course, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 hours will be waived. I'm going to want field visits 1 time per month.
At his parents' home, Your Honor?
That's where he's living. Yes, wherever he's living. There is going to be regular reporting by Zoom or in person. There's going to be regular UAs, and I'm going to want a UA today. And probation, if you want to consider the field visits as reported, if you all choose to do that, you can. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Is there anything you need from the court? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. And what are the results of the drug test going to be?
Possibly negative.
I'm sorry?
Possibly negative.
Why do you say possibly negative? What could it be positive for?
Positive.
Okay, what is it going to be positive for? Possibly.
Weed, marijuana.
All right, you shouldn't be doing heavy machinery or doing the work that you're doing with drugs. You understand? And when you're on probation in this court, you're not allowed to use drugs. I know people think marijuana, that's no problem, but it's still illegal in Texas. Do you understand? All right, they're going to give you a UA today. All right, thank you.
Thank you, Your Honor.
And probation, can you make sure if he's positive for marijuana, I'm going to want him tested for levels then? Thank you. Nathan Martinez. Brenda, it's Old Home Week. Kelly was just here.
know, you dismissed Kelly.
By the way, I forgot to ask, did my motion to withdraw get signed on?
Yes.
It did, thank you. Thank you.
All right. We were here on November and today is his plea deadline day.
Yes, Judge, they've made us an offer that he's not interested in. We also, in the meantime, had him evaluated for the drug court. Unfortunately, he didn't qualify, so.
All right. So the offer tendered today, was that an offer just tendered today or?
It was the same basic offer we've been tendered in the past.
All right. So you're requesting a jury trial?
That's correct.
All right, Ms. Ferguson, I need a jury trial date for Mr. Martinez. All right. And state, how long do you expect the trial to last?
Judge, she's got a few cases, but like each case individually shouldn't be that long. So, I bet less than a week.
Are there videos?
No lengthy videos.
Okay, we're gonna see people are qualifying the videos, like when you guys say no lengthy videos.
About videos, there's potential videos that can come in, portions of body camera, that type of thing.
Okay,
No, there are no 10-hour police statements or anything like that.
Just realist style video.
okay. Because I want us to start like if it's less than 13 hours, that's our baseline. Okay, start with less than 5.
Yeah.
Well, maybe 4 if you're gonna be sitting on the witness stand.
Yeah. I can do the 14th of March.
All right, March 14th.
March 14th.
Yes, okay, so Mr. Martinez, your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. You will be brought over for trial on the 14th, dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll have to do a clothing exchange. Counsel, if there's an issue with the clothing exchange, let the court know.
Thank you, Judge. I appreciate it. And we'll continue to communicate with the prosecution.
All right, thank you. We're done with Martinez.
Thank you, Nate.
Thank you, you too. Did we just do David Sanchez?
Yes.
Okay. No. Yeah. I think the paperwork went somewhere else. Let's see. Okay, I hope it's not in another file.
Yes, Your Honor.
Okay. That one's done. Yeah, that's done. Placido Jaquez.
Lácido.
I'm sorry. It was just done.
Oh, I.
I get roped into something.
This is what we're talking.
Oh, okay, that's right.
All right. For this one, there was a discovery issue.
Judge, I think we have all the discovery. The short version, I think, is we need some time to be able to show it to him. It's a lot of
Okay.
several incidents. And we also are in a situation where I understand from the state that this is a first chair case and they are awaiting the arrival of the first chair.
Yeah, but you know what, I feel, I've already told everybody who has a law license.
I'm happy to let
Yeah,
Oscar decide.
We conferred.
Yes.
We were talking about possible resolutions,
Okay,
and so I'm thinking of what I would offer Mr. Martin.
See? there you go. Norma, on Mr. Placido Jaquez, can we bring back this in 30 days?
Judge, I believe you gave us a setting on the 24th on my other case. Could we do that on the same day?
Oh, January 24th?
Yes, ma'am.
All right, January 24th. All right, and state on that date, I'm gonna expect you to be prepared to make an offer. All right, we'll see you then.
Thank you, Judge.
You're welcome.
I'll make one.
And if y'all want to come back sooner, you always can.
Yes, ma'am.
I'm gonna read this.
Oh, okay, awesome.
I like it, good. Anybody with a law license. I saw that movie. My cousin did. But it's not yellow, it's yellow.
I was gonna ask you. Can you tell me how many days that he's been in custody since his most recent arrest? His SID is 7020777. Number 60 or more.
Thank you so much.
Caroline, were you able to find it? Okay, thank you. I'm so sorry.
No.
Judge, can I go?
For,
Just personal comment.
oh, sure.
Thank you.
Come with your first, can you mute us, please? All right, John Garza. Who's here on John Michael Garza? Yes.
Take care.
All right, my understanding he has pending family violence cases.
Judge, that case has been indicted. So now we have an offer. I need to, my client's considering the offer. We've just gotten that in the last 60 to 90 minutes.
All right, Ms. Ferguson, on John Garza, if we can come back in 1 month, that's your plea deadline date. All right, January 23rd, Ms. Ferguson will give you the reset form.
Judge, with regard to his bond conditions, if we need to file something to modify those.
Yes.
If it's not agreed to, does that get referred, or how do you guys handle that?
If it's agreed to, or if it's not agreed to, I still need to hear it based upon the new law. So just speak with Ms. Ferguson and she'll put it on the docket.
Okay, wonderful. Thank you.
Arturo Rivera. Yes. All right, and probation, this is no application. Court is calling 2022 CR 0978. And counsel, if you could move back from Brenna. I know you're reading, but she feels like, hovering. Okay. All right, court is calling 2022 CR 0978, State of Texas versus Arturo Rivera. Can I have parties announced for the record for the state? Defense?
Judith Wemmert.
And are you Mr. Rivera?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am, we have.
Court will find that the state is in compliance with discovery. Mr. Rivera, I'm showing you what's entitled true bill and an indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rivera, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the counsel? Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Rivera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Extremely satisfied.
Are you a U.S. citizen?
Yes, ma'am.
We're not like it. He is extremely satisfied with the way he's been represented.
It's been very, very kind to me and I appreciate that.
That is awesome. I love to see kindness, you know?
So do I.
Yes. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
I did not.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's an affirmative finding of deadly weapon, $1,500 fine. State will take in consideration 2022 CR 0956, 2022 CR 0203, 2022 CR 0202. There's an affirmative finding of family violence. There's to be no contact with Jonathan Pena or Brittany Cano. Did you understand that to be the plea?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Knowing that, do you still wish to proceed with the plea?
I do.
Defense, is that the plea?
Yes, ma'am.
State, is that the plea?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
I did, ma'am, yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
All right, off the record for a moment. Deputy, could you move them to that end? All right, we're back on the record. State, do you have any evidence to support the defendant's plea?
Yes, Judge. State would author what's in Martin States one.
No objections from the defense.
Mr. Rivera, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there would be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Your Honor, just that we ask that the court follow the plea bargain.
All right, the court will sentence you to 4 years in the prison. There's a $1,500 fine. Time and money will run concurrent. Take in consideration 2022 CR 0956, 2022 CR 0203, 2022 CR 0202. There's an affirmative finding of family violence, and state, is the complainant aware of this offer?
Judge, I'm not sure. Communication has not been.
But she is aware that you all were proceeding to work out an agreement?
Yes, Judge.
Okay. And did she have any objections to that?
Aware, Judge.
All right. There's an affirmative finding of family violence. There's to be no contact with Jonathan Pena or Brittany Cano, Cano. And the court will give you credit for any time served. And there's also an affirmative finding of a deadly weapon. Is there anything else from either side with regards to sentencing?
Nothing from the state, Judge. I think from the defense, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
Because this is a felony conviction and also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Good luck to you. We can go off the record. You are not to have any contact. You understand what that means, correct? That relationship is over. She doesn't want to be with you. And if you contact her, what's going to end up happening is you're going to have potentially more cases. Do you understand? All right. Good luck to you. You're welcome. Yes. Who's here on Jonathan Ramirez? Just have a seat. I don't see your attorney, sir.
No.
He's with someone else. Okay. I'm sorry, Joseph Anthony Ramirez. I'm making up names. All right, where's Mr. Ramirez? Come forward. All right, court is calling 2021 CR 8064B, 2021 CR 8065B, 2021 CR 8076B, 2021 CR 8084B, and 2021 CR 8072. State of Texas versus Joseph Ramirez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Raymond Martinez for Mr. Ramirez.
Are you Mr. Ramirez?
Yes, ma'am.
Mr. Ramirez, your counsel has filed a motion to withdraw. State, do you have any objections?
No, Your Honor.
Do you have any objections, Mr. Ramirez, to the motion to withdraw?
Judge, actually, we just had a conversation about it. I told him I would stay on till the next setting, and if on the off chance we can work all his cases out, he's set for January 10th. And if we can't, and it looks like it could turn into a lot more work than what we think it might be, then I will re-urge my motion. He was a previous failure to appear, judge, as part of the problem. That's why he's custody.
All right, we're going to come back on January 10th. All right, thank you. Guillermo Rodriguez.
Good afternoon, Your Honor.
Good afternoon. What is happening with Mr. Rodriguez?
Your Honor, I believe this is our first sitting and they're trying to reach out to the complainant so that an offer can be made. If they want to get that done in the next day or two, or if you're in court next week, we could be back then to review the offer and see if it's something Mr. Rodriguez would be interested in. Otherwise, we'll come back when the court's held to stay.
All right, Ms. Ferguson, when can we have this brought back?
Oh, next weekend.
The 19th should work, Your Honor. Yeah.
I understand.
I've got some, we can be back on the 19th. Your Honor.
All right, we'll recall you on the 19th.
We'll see you then, Judge.
All right, bye-bye. Who's here on Jasmine Hardaway? Yes.
He's here.
Yes. So I'm assuming this is, we have the discovery.
Discovery compliance, yes, Your Honor.
Yes, what is happening?
The state conveyed to me the discovery on the, what I guess you could refer to as an extraneous offense that was conveyed to me by Mr. Sanders.
Okay. So you have all the discovery on that case?
As far as I know.
All right. So Ms. Ferguson, on the 2021 CR 1111 case, I need a jury trial date.
January 23rd would be probably unworkable for me. I have a trial setting in U Valley that.
Oh, we just need to see what's available.
That's not a family violence case, correct?
No.
I can do March 21st.
All right, March 21st. And because there's new discovery that was tendered on the other case, March 21st will actually be her jury trial date and plea deadline date.
Now, is that jury trial date on both cases?
I'm assuming the state is,
Case one falls through.
yes.
And guess I have to figure out who I'm going to be conferring because Mr. Sanders is no longer.
Oh, well, everybody over there has a law license.
Well, I understand that part, but I'll have to figure out which one's applying here.
Okay.
Thank you.
All right, thank you.
March 23rd.
Third.
Third.
Ms. Ferguson will give you a reset form. Okay, I'm going to take up Philip Singleton, then Carlos Romero. Philip Singleton. Come forward. Today is his plea deadline date. Hello.
Good morning.
Good morning. So where are we?
Your Honor, I have just
there's some videos that I haven't been able to upload. We're trying to upload those that the states told me they'd been uploaded, but for some reason I haven't been able to see them. Before I can enter a plea, I've got to see those videos.
All right, Ms. Ferguson, can we recall Mr. Singleton for the third week in January? No, he's in custody. I'm sorry, he's on bond.
Okay.
All right, January 19th. See you then. Ms. Ferguson will give you a reset form.
January 19th, great day.
Yes.
Thank you.
All right, and then Carlos Romero.
Yes.
Thank you.
Judge, we don't have an agreement.
Okay. All right, in just 1 second. Norma, on Gregory Gonzalez, what is his attorney's name? Ah. All right, can you give the state's attorney her number so someone can confer with her by phone because she's on Zoom? All right, thank you. So, Mr. Gonzalez, I'm going to put you back in the waiting room. Well, actually, you know what? Let me assign you to a breakout room and just wait there until I ask for you to be removed. And Monica, if you could go to a breakout room and a prosecutor will call you by phone.
Yes, ma'am. Thank you.
All right, you're welcome. So I'm going to put you in breakout room number 1 with your client. All right, we're on the record in 2021 CR 5583, State of Texas versus Carlos Romero. Could I have parties announced for the record?
Oscar Smith, from State of Texas.
Community Scotts for the defendant.
Bridget Garza for defendant.
All right. So I know there was a previous case that I guess was dismissed.
Correct.
And so now we're just proceeding on the burglary of the habitation for a bond reduction. State, are you ready to proceed?
Not as ready as I'd like to, Judge, no. But I will say that that prior case, yes, it has been dismissed, but it was dismissed for further investigations. Again, a further investigation, case, just so the court's aware of that, wasn't dismissed for another reason.
Okay.
What I've looked at.
Okay.
Well, I don't know what that means, further investigation. I had a Neem Jones for further investigation. It took him 36 years to bring a case. So.
All right, well, here's the thing. The court is here on the motion for a bond reduction in 2021 CR 5583. That's the only case that the court has see that is pending against your client.
That's right.
All right. So defense, do you have any witnesses or evidence?
Witnesses, we're not gonna call any witnesses, just in terms of argument and our position on it.
All right, so just 1 moment. State, do you have any witnesses or evidence?
No, but I would like to do reports.
Okay.
My apologies, Judge.
Oh, no problem. I think everyone has been very patient. And defense, I appreciate your patience because you're at the top of the pile and then you found your way at the bottom of the pile.
Yes, my fault, Judge. If I live, I could have.
Oh, no.
And looked at it last night or something, so my best. And I don't want to just submit the 45.
No, go ahead. Do you need a little bit more time to look
No,
over?
I think I'll submit these 3 pages.
Okay.
We established it. what the link is to this defendant and the offense that he's currently charged with.
Okay,
Just so that the court's aware of that, and it does give some other information. Circumstantially, what is involved in the case.
okay.
The court is aware there was another offense that was attached to this offense, which has been rejected, which was rejected for further investigation. So of course, the state's contention that that case is still ongoing and existing with the police department and or our office. State's Exhibit 1, which is 3 pages from the reports that have been tendered to defense counsels via discovery. State moves to admit what the market states.
Have you had a chance to review those, counsel? And
I've seen it previously. And
any
we
objections?
don't have, for purposes of this hearing, no, but we don't have to.
All right.
So the court's where I did underline, I think it's on page 2, it establishes that his fingerprint was located on piece of evidence, which is what ties into the burglary of the house.
Okay.
And
All right. Any other evidence from the defense? I'm sorry, from the state.
No, not at this time.
All right, then, defense with no evidence, I'll hear argument.
we'll waive opening, Judge, and we'll close. Principal's office. We'll waive opening, we'll close.
All right, so do you have any argument or no?
Yes, we're gonna, if the state is we're gonna waive the opening argument. And we'll just.
Thank you.
Oh.
Because you know what, I will tell you, I always, when it's a defense motion, I always have you prepare if you want to give your first argument and then you get the last argument. But now I understand what you're saying. All right, state.
They were reserved for rebuttal.
No, because it's their motion.
Oh, I guess I'm getting a little confused there.
Yes.
I think the bond is sufficient at $150,000. It's a burglary habitation that involves a pretty extensive offense, as you can see in the report that's been submitted into evidence. There's, as I stated before, there is another case that is attached to it. Granted, that case is no longer pending in this court, but it is still under further investigation, which is one of the reasons that it was dismissed and rejected. In the event that the court does lower the bond to a bond that defendant does make or is able to make, the state would ask that his defendant be placed on GPS, and then the state would also ask that those fees be waived, but that he be placed on GPS for that. At some point, we can know where he's at and make sure that this case is resolved in the future.
All right, defense.
Our position, Judge, is that the state mentioned this about the case is still under, the other case is still under investigation. Problem we have, Judge, is that my client has been in jail for 26 months. In a 26-month period of time, the state was given a lot of latitude. We didn't push, we didn't urge, because we were giving them sufficient time if they were going to bring a charge, to bring a charge. And if the capital murder case that they charged him with initially, if they hadn't filed it, he would be entitled to a PR bond. Anyway, so our position, Judge, is that you can't hold someone 26 months and put in my opinion, an excessive bond on a burglary case and try to allude to the underlying case that if they had the evidence to indict it, you don't need probable cause to indict the case. To indict the case, then indict the case. You just can't keep making reference to something that you don't have in order to keep someone locked up in jail. We feel that $150,000 for a burglary of a house is unreasonable per se. I practiced it, a few years in Sandra. I've never seen $150,000 on a burglary case. So just to try to keep in here because you can't prove something, I don't think it's fair. I'm thinking it's right. Our position judges on a case like this, for whoever have a case, if the bond is set at say 40,000 or 50,000, that's more than enough that fits the case. He doesn't have an extensive criminal history. And we just feel that that 26 months in jail will give the case sufficient time.
All right, can you mute us for a moment, please?
Yes, sir.
All right, defense.
We'll call the we'll call for no.
All right, and the defense is, for the record, the defense is reopening. Any objections from the state?
No objection. Judge.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Carlos Romero.
All right, defense.
Thank you. Sir, you're the same Carlos Romero that's charged with burglary of a habitation, correct? Yes, sir. Now, you've been in jail on this charge for how long? 26 months. 26 months. Have you been able to work since you've been? Do you own a house in the park? No, sir. Do you have any money in the bank that you can use? Yes. Okay. If you use money that you had in the bank, how much do you have? 1,500. So that's the most you can. Yes, sir. You live here in San Antonio? Yes, sir. You're born here in San Antonio? No, sir. How long you lived here? I've been 12 years old. We pass with.
Any questions?
Yes, if released on bond, where would you be residing?
My grandma's house,
And where's that located?
conversation.
How many people live in the home?
It's my grandma, my aunt, and my cousin.
And how old are the people that live in the home?
I don't know how old my grandma is. My aunt's like 40, and then my cousin's like 22.
Is that the only family that you have in San Antonio?
Yeah, my mom moved to Virginia while we were in.
And as far as family members, have you asked them to help you out in any way to cover bonds or anything like that?
I haven't discussed my bond.
Have you reached out to any bondsmen since being incarcerated?
No, sir.
Have you attempted to reach any bonds? Okay. Outside of your mother, I think you said your mother was out of state. Do you have any other family members that reside out of state?
Not that I'm close to.
Any that reside out of the country?
No.
That's what it is.
Nothing further.
All right. The court has reviewed state's exhibit number 1, but is there any evidence that anyone wants to submit as far as it's related to this actual case?
Well, just in terms of, I mean, I would imagine the court has looked at the report that the state has. And basically, if we talk about evidence, there's a print. It's still going to be an issue in terms of when that.
No, but I mean, any evidence related to this specific case, because we're here for a burglary of a habitation. The evidence that's been submitted to me has a date of October 8, 2020. And the alleged offense of this date is August 16, 2020. State's exhibit number 1 related to this case?
Should be, Judge, if that was located on discovery.
They're both related to the same offense.
Because it's just that as I'm reading state's exhibit number 1, it doesn't appear to be a part of a burglary.
They're
Because in the instant case, I have a complainant's name, but I don't see that complainant's name in the documents that were submitted to me. And this is the reason why the court is asking, because you all are coming for a bond reduction. I don't know anything about this burglary of the habitation because all I know it's a burglary of a habitation and I have the complainant's name.
I think that.
Can we go off the record?
Yes. All right, if you can mute us. to the state's withdrawing state's exhibit number 1?
No.
All right. Then that will be withdrawn and we'll finish this hearing tomorrow. Okay, so you'll have a decision tomorrow. All right, thank you. I appreciate you guys. All right, Monica, did you need something?
Good morning, Judge. I've got Gregory Gonzalez. You recalled us for today so that we could enter a plea and you were going to consider sentencing at a later date. We're just waiting on plea paperwork from the DA's office. I don't know if you want to recall us for this afternoon. But if you recall, I have a prior engagement tomorrow, which puts me out.
Yeah. We have actually a new attorney in here right now.
Okay.
Were you able to do it on Monday or no?
No, I'm out until the 2nd of January.
Okay. All right. State, do you think you all will be able to get the paperwork together? If not, we'll have to do it in the new year.
I'm working on it right now.
They're working on the paperwork right now.
Okay. Sounds good.
All right. I'll send you in the breakout room with your client in breakout room number 1.
Thank you.
Alicia Small.
Small.
Yes. And who's here on Donald Davis? Okay, you're in the stack. Court is calling 2022 CR 10402 State of Texas versus Alicia Small. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense? Are you Ms. Small?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Small, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Small, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with evading arrest detention with a vehicle? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand, Mr. Simmons? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Small, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, there's a $1,000 fine probated and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Can I have parties approach?
Yes, sir.
All right. All right, I'm showing you what's outside the agreement. The state is requesting that your community supervision be for a term of 2 years and there be 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the officer's charge, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, state officer states for one in all attachments.
No objection.
All right, Ms. Small, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sure.
Anything you wish to say on behalf of your client?
We pray that the court follow the plea agreement. We would also ask the court, she's fallen on some hard financial times, so we'd ask the court to consider probating a portion of the fine and give some consideration to possibly being able to get credit for some of our community service via employment and or education.
All right. Do you have any children? What are their ages?
10.
Just one? And is your child living with you?
No.
Where's your child staying?
In Indiana.
And who is your child staying with in Indiana?
His father.
When you're drug tested today, what are the results going to be?
Negative.
Have you ever used drugs? What?
I've used narcotics, pain pills.
When's the last time you used pain pills?
Oh, it's been a couple years.
So why is your child with his father and not you?
Because his father lost his job. They got the best child custody lawyer. My house caught fire just here recently, and his dad just took up and left. He didn't have a job. He lost his job and he couldn't live work down here. He has more family at home, back home, so he took him and left.
So when's the last time you saw your child?
It's been over a year.
Okay. So are you employed?
No, ma'am.
So how do you support yourself?
I stay with my boyfriend.
And who is that?
Esther Romero.
And what does he do for a living?
He's a manager at electrical company, Country Electric.
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. I'm going to want a UA today. I'm going to want a TAP evaluation. Follow the recommendations of TAP. If TAP says inpatient treatment, we're going to start with outpatient treatment. You're going to have to get employed. Proof of employment within 30 days. And there's a lot of seasonal work going on now. So proof of employment within 30 days, no employment as a home health care provider or with minors. And the home you live with, is it just you and your boyfriend?
His 2 sons.
How old are they?
They're in their 20s.
Okay. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you get the COVID vaccination, but if you do, 40 hours will be waived. I'm going to ask for parenting classes with Triple T. Once you complete that, the remaining of the community service hours will be waived. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month until further notice. And probation, if you want to count the field visits as her reporting, you can. And we are going to do the UA hotline until further notice. And we'll start off with UAs once a week. And then if there are no issues, you can taper that down. Probation, is there anything else she needs? Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. You're welcome. Who's here on Starlin Rodriguez?
Excuse me.
Yes.
Merry Christmas.
Oh, Merry Christmas. All right, today is her plea deadline date. So what are we doing?
Well, actually, Your Honor, we filed a motion for discovery as there were some, this is a death case, and we were trying to work towards a plea agreement. All we were asking for is confirmation of the value of the items that were not recovered. And that's where kind of where we're stuck. And so from the last time that we were here, we came in, we had asked the state, and the state was going to work with the complaining witness to get us confirmation of that. As I learned today, that phone call wasn't made until just yesterday, and they have not received anything yet. I filed a motion for discovery in an abundance of caution in the event that this had to go to trial, that I didn't want the complaining witness showing up at the 9th hour with, oh, look, here are my receipts. I mean, we either know what they are and we make it part of restitution, or we don't.
All right, Ms. Ferguson. On this case, I need a jury trial setting and a plea deadline date. So state, how long is this trial going to last?
Your Honor, there are a number of witnesses. Please say 3 or 4, but 3 is probably more accurate.
Okay. All right, Ms. Ferguson.
February 21st.
All right, February 21st is going to be your plea deadline date and your jury trial date. If you decide not to accept a plea, then you'll be going to jury trial. Yes.
I actually start a federal trial in Houston on the 15th, Your Honor. We have jury selection the 15th, and then we start our trial on the 16th, and that's going to go for 3 weeks.
All right, well, let's see if that happens. Sometimes miracles happen. You may be getting ready for your federal trial, and they may come in and say, we're dismissing it. So we'll see.
Wow. Okay.
See, I mean, it could happen.
I would take that in a heartbeat,
Yeah.
given the situation, but
It could happen.
the motion for discovery, Judge, do we want to set that for an actual hearing, or?
State, where are you on discovery?
And the only discovery that's pending, Judge, is just what we spoke about, was just receipts from the victim to confirm the value of the items that were not recovered.
And Judge, that's information we asked the victim. He said that he'd be sending us the information in the form of a spreadsheet. That was yesterday, or at least when that.
Well, if they don't have any amount for you, then amounts will not be admitted.
Okay, and that's the thing, is I just don't want them coming in at the 9th hour.
No. Okay.
All right.
All right, who's here on Leroy Settles? Court is calling 2022 CR 10419, State of Texas versus Leroy Settles. Could I have parties announced for the record for the state?
Daniel S. Clark, the state of Texas.
Defense?
Lauren Lepton.
And are you Mr. Settles? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Settles, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading on the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Oh, Your Honor.
Mr. Settles, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Thank you.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Settles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on 1244B, a class A misdemeanor punishment with the misdemeanor conviction, and they're requesting that your time be set at 44 days in the Bexar County Jail, and there are no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it
Yes.
in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
No objection, Your Honor.
Mr. Settles, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask the court follow the plea agreement and just satisfy the judgment.
All right, the court will find you guilty. The court will follow your agreement, sentence you to 44 days in the Bexar County Jail under 1244B. Give you credit for any time served, and the court will show that the judgment is satisfied. Is there anything else from either side with regards to sentencing?
No, Your Honor.
All right, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, and just give me one moment. All right. All right, good luck to you.
Thank you.
All right, you need to get help. You understand? All right.
May we be excused?
Yes.
Have a wonderful holiday.
You too. You too. Thank you. Mr. Brooks, who are you here for? All right. Robert Luna. All right, so we're supposed to be here for GSR reports or something?
We're still waiting for the report, Judge.
Did they give you an idea of when the report would perhaps be here?
I think they're still waiting to hear back from the detective, but if you want to set us for a plea bargain deadline.
Okay.
In January, early February, I think we'll be good to go by then and have a decision for the court. as to
All
whether
right,
to
thank
file
you.
or not.
All right, Ms. Ferguson, can I have a plea deadline date at the end of January for Mr. Luna?
Would it be possible to do February?
She says February 2nd.
Oh, February 2nd. Excellent.
All right, is there anything else?
Not at this time. Happy National Cupcake Day, Judge.
Yes. What?
What? You didn't know?
I didn't know it was National Cupcake Day.
Everybody say that.
You know what? People disrespect the cupcake because it's lesser of the cakes of the cake family.
I like it. I feel
I do
better
too,
about
yeah.
it too. I'll have 3 or 4 of them.
But do you like the tops? Or is that muffin tops from Seinfeld?
Muffin tops.
Yeah,
This is the best part of the muffin.
yeah, it is.
Thank you, Judge.
You're welcome. Thank you for your patience.
Thank you. Have a great holiday.
All right, thank you, you too. All right, who's here on Donald Davis? All right, so what is happening with this case?
We haven't agreed bond reduction, Judge.
All right. Just give me a moment on this one. All right, just give me a moment. Gregory Gonzalez. Gregory Gonzalez.
We're doing the plea with that's Monica.
Ah.
Still waiting for paperwork.
Okay. All right, thank you. Okay, and this one's done.
Hector wanted to approach on Scarlett for just 2.
Yes, Starlin.
Real quick, Judge. My client is out on bond. We have her on the ankle monitor, so she has partial house arrest. She gets her work schedule, which she's been working for Bill Miller since she got released, and she sends her to the pretrial officer. However, her pretrial officer limits the hours she can work, denies her working weekends. Bill Miller wants her to work through the holidays. She's not letting her. So I was hoping we can direct them to be a little more lenient with the work schedule, especially since they're wanting to give her more hours at work.
All right. Well, can you pull a B page? She's allowed to work.
Right, but pretrial officer, for whatever reason, is limiting.
No, I'm saying she's allowed to work. So I'm gonna write in there, she's allowed to work.
Okay.
But she is going to have to provide, her documentation.
Every week she sends her schedule a week
Yes.
in advance.
Yeah, so I'll write in there, she's allowed to work. All right, who's here on Jeremiah Johnson?
That's Mr. Adolfo. He's on Zoom, Judge.
Yes.
Hello, Judge. How are you?
Hi. And what are we doing with Jeremiah Johnson?
Your Honor, this case had been reset from November 29th. It's my understanding they're going to withdraw the MTR and allow it a condition. The only reason why it was reset, Judge, was because I had conferred with Marcus and they wanted to get the tap done before he was formally released back on the probation. I had spoken with Miss Abrams last time.
Yes.
And I believe they tried to do a rush on it. I don't know if the tap has been done yet, though.
Oh, the tap has been done. And
That
what are
makes
the
it easy.
recommendations?
The recommendation was for intensive outpatient treatment with probation, monthly drug testing, documented sober score meetings, at drug credit.
All right, so my understanding of the state is withdrawing the motion.
Yes, Your Honor, stated with the motion.
All right, so alternate amend conditions to follow TAP recommendations. And they want your client in outpatient treatment.
Okay, thank you, Judge. And I had already discussed with him all of this ahead of time. So he just wanted the court to know he's motivated to comply.
All right, thank you so much.
Thank you. Maybe
You're
excuse, Your Honor.
excused.
Thank you.
Yes.
Have a good one. Have a good cupcake day. Apparently it's cupcake day.
Yeah, I just learned.
Take care.
You can send him back, correct?
Yes. Oh, I don't know if probation needs to have him sign conditions.
Oh, I'll archive that.
Just give me 1 second, Mr. Martinez. mute us? No?
Yes.
Yeah. I sent it with the consent.
All right. Did you all fill out the trial court certification? For
Yes, Your
defendant's rights to appeal?
Yes, Judge.
Okay, and if you don't have that, that's fine, because they're gonna have to come in anyway. Yeah. Yes.
I was gonna say too.
Bye-bye.
You know what, Judge, that trial court certification, I know I signed it yesterday or early this morning, but it didn't get to my client because the email address was incorrect. I'm not sure if it got resent out to him, but it
Well,
was
that's
not.
okay, because the sentencing is gonna take place on a different date.
Okay.
He will have to come into court and we can do that at that point in time.
Yes, ma'am.
Thank you. Oh,
Judge,
Brenna.
we're being true to our festive schedule.
And I think we can now do we can evaluate it.
I like it. 12:30 and you're not, you're gone.
Yeah.
It works.
It does work. People will show up on time.
And then they will show up on time the next day.
Yeah. All right, the court is calling 2022 CR 7822, State of Texas versus Gregory Gonzalez. Can I have parties announced for the record for the state?
Daniel Escobar for the state detective.
Defense?
Monica Corrala for defendant.
All right, we're proceeding by Zoom. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Gonzalez, you understand that you have a right to appear in court. Do you understand that?
Yes, ma'am.
All right. And are you waiving your right to appear in court and you're asking to appear by Zoom?
Yes, ma'am.
All right. The court will find that defendant has knowingly and voluntarily consented to appear by Zoom. Showing you, counsel, the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the repeater enhancement.
Any objection?
No objection.
Mr. Gonzalez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client, I'm sorry, Mr. Gonzalez, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he is currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states exhibit 1 in all attachments.
No objection.
Mr. Gonzalez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. When are you requesting for sentencing, counsel?
Your Honor, the week of January 20th or later. He has some affairs he needs to get in order, and I have a human trafficking case that's special set with Assistant DA David Lunan. And so if we can get it, I guess, Monday, the 26th that week, or sorry.
When is your trafficking case set?
I believe it's the 10th is when they want to do jury selection. And it's anticipated to be a 1 or 2 week trial. So I think it's going to go into the second week for sure.
All right, I'm only going to give him to January 9th. And so your sentencing is going to take place on January 9th. You need to be in court at that time.
Your Honor, we are supposed to pick the jury. I received an email, even though we're set January 10th, I did receive an email. The court was asking if we could pick the jury on the 9th. And if I can get that email popped up real quick, I can confirm that.
What time are you selecting the jury on the 9th?
Jury selection at 1 p.m. on the 9th.
All right, so we'll do this on the 9th at 9 a.m.
Yes, ma'am.
All right, thank you. And next we have to address your violation, Mr. Gonzalez. The court is in receipt of a violation for a high BRAC reading.
What was that?
So do you still have ignition interlock on your vehicle?
Yes, ma'am.
And are you using that regularly?
Yes, ma'am.
All right, so this is what the court is going to do. I'm going to continue you on the ignition interlock, but you're going to do the DUI education course. You understand?
Yes, ma'am.
So you need to have started that before you come back to court on the 9th. Do you understand?
Yes, ma'am. I just need to know what I need to do.
Oh, your pretrial services officer will be in contact with you, and make sure you contact them. Your officer is Leslie Lopez. Do you have her contact number?
Yes, ma'am. I email her once a month whenever I get the interlock calibrated.
All right, just contact her and I'll see you on January 9th at 9 a.m., okay?
Okay.
All right, thank you. Thank you, Mr. Gonzalez.
Thank you, ma'am.
Thank you.